Good morning, Ms. Nagy. Can you tell me your name? You have to unmute, ma'am.
Can you hear me now?
There you go.
Okay.
I can. Tell
My
me
name
tell me your name, please.
is Faith Lynn Nagy.
All right, Trooper, good morning. Your name, please.
Yes, good morning, Your Honor. Trooper Byer, Michigan State Police.
All right, is there an offer here? It looks like she's got a pretty good record.
Yes, Your Honor, I'm fine with impeding due to her driving record.
Do you want to plead to impeding traffic, young lady?
Yes, ma'am.
What's yes, ma'am?
I mean, yes, sir. Sorry.
All right. No worries. Relax. Take a deep breath. To the charge impeding traffic, responsible or not responsible?
Responsible.
That's 0 points. It won't go on your record. Why were you driving so fast?
I was trying to get onto the freeway and there was just the semi trucks coming, and I have been ran off the road before by the Ford trucks when they were all driving down, so I just go.
All right, I'll accept the plea, dismiss the original charge. 160 is your total. Can you pay that today, ma'am?
If you'd like, I can pay that today, yes.
You can go on 33court.com with a credit card or debit card, whatever, on with your case number. Okay, with your case number. Okay.
Yes, thank you.
Have a great day, young lady. Thank you, Trooper. Have a good day. Be safe. Thank you.
You as well. Thank you.
Now you. Morning, Mr. Jadala. Your appearance?
Click for Your Honor, Sam Jadala, P62186, appearing on behalf of BioSci Logistics.
All right. All right, this is I can't even read the ticket very well. Is this an overheight ticket?
I believe it's an overweight ticket, correct, Judge?
Boy, I can't read that. He writes it worse than I do. At any rate, so you're going to plead to overweight, and the agreement is $1,400 plus court costs, correct?
Correct, Your Honor.
All right, you're authorized to enter this plea on behalf of the defendant?
I am, Your Honor.
To the charge of overweight, responsible or not responsible?
Having the authority to do so, we plead responsible, Judge.
All right, I'm going to add 200 in court costs. 1,600 is the total, and I will give them until March the 28th. Okay, March the 28th. Have a good day. Thank you, Mr. O'Neill.
That is correct.
I need your appearance, and I need you guys to start your videos, please.
Thank you, sir. I'm sorry, I'm in another courthouse right now. But this is Daniel Reed. I'm the attorney for Mr. O'Neill.
Good morning, Mr. O'Neill. You have to unmute and state your name, please.
Marcus O'Neill.
Okay, so we'll go on the 18th. You guys want the exam? We're going to go on the 18th, and that'll be at 10:45. Okay.
All right, give me one quick second. This is my paralegal. Okay, I'm sorry, Your Honor. So you said the 18th?
That's okay. March 18th at 10:45, and that will be in person.
That is fine. 10:45 on the 18th. We have it. So that's what we'll see. Thank you very much.
Have a good day, Mr. O'Neill. You have to show up in person that day. Okay.
Okay.
All right, we'll be there.
Luck.
Thank you, Your Honor. We appreciate you,
very
Gordon.
much.
Good to see you as always.
You too, Mr. Reed. Thanks. Sharman.
All right.
Aman Sharma, 25M6465-856. Good morning, Mr. Sharma. Your name? I'm sorry, Ms. McCandless, rather. I apologize.
Yes, Your Honor. Good morning, Your Honor. Let me canvas. Nice to see you.
How you doing, Mr. McCandless?
Good, Judge. How are you?
Pretty good. So you're authorized there in this plea. They're going to offer you impeding traffic. The improper lane use will be dismissed. Let me just check something. You must have an out-of-state record. Yeah. All right, so you're authorized there in this plea on his behalf, right?
Yes, Your Honor.
This is a passenger vehicle though, right?
No, this is a truck driver, Your Honor. This is his.
Oh, it is?
Yeah, passing through.
Okay, I see. It's out of Ontario. All right, to the charge impeding traffic on his behalf, responsible or not responsible?
Responsible, Your Honor.
I'll accept the plea, dismiss the improper lane use. Why is everybody driving? He's driving in the left lane, right? Why do these guys do that?
I think, Your Honor, that some states don't have that law, the third lane. So Michigan does have that law that the trucks aren't, but then sometimes depending on the way the road signs, though, they can direct them in other directions. So there are lanes, place in Michigan where they say trucks drive only in the left lane. So if you ever drive up by M14 on 94, you'll see that sign.
I know.
Yeah.
All right, well, I'll accept the plea, 210, pay by March the 28th, okay?
Yes,
Have a good day. Good to
nice
see you
seeing
as
You
always.
too. Thank you, Your Honor. Have a good day.
Okay, people against Amanda Justine Garrett, 25T700567. Good morning, Mr. Bulahanis. Ma'am, your name?
Amanda Garrett.
Mr. Bulahanis, good morning, your name?
Good morning, Your Honor. Greg Bulahanis on behalf of Amanda Garrett.
So on this case, let's see here, what do we have? We have a super drunk charge, we have an old OWI occupant less than 16, and we have OWI, and he's going to dismiss counts 1 and 2. Your client's pleading to count 3, true?
Yes, Your Honor, no contest.
Why no contest?
Lack of recollection.
What was the blood or breath result?
It was over a point, it was like 0.25 or something like, it was high, very high.
There was no accident, though.
No accident.
You don't remember this, ma'am?
And the reason that they pulled her over was she was going over the speed limit.
You don't remember this, ma'am?
Yes, speak up.
No.
We'll stipulate to the.
Let me see. I don't have a police report here, I don't believe.
I have the police report. May I approach? Your Honor?
Yes. He's got guilty here. Is he consenting to a no contest plea?
Yeah,
I mean, look, here's the thing. If she truly doesn't remember, that's one thing. I'm not going to establish something here where there's a 2-5 and above, and everybody's going to come in here and tell me that they don't remember.
no.
All I need is enough for a factual basis.
Well,
You're an officer of the court. If you're telling me she doesn't remember, that's what she's conveyed. That's one thing. But I mean, I've had people tender guilty pleas with 3 5s and 3 2s and 2 9s, and
there's a potential litigation. If you look at the first charge, Your Honor, so besides lack of recollection, there's other potential litigation.
Is this her child?
Huh?
This is her child?
Yes.
How's that litigation? There's no way.
CPS
Hang on.
CPS could be contacted regarding this type of charge, Your Honor.
I'm not going to take a no contest here. Okay? I'm just not going to do it.
Okay, well, I'll do the best I can to establish a factual.
I'll do the best I can. Ma'am, if you plead guilty, possible penalties here are up to $500 in fines, 93 days jail, 360 hours community service. Court costs are all 6 points. License suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. If you plead guilty here, I'm going to dismiss count 1, which is OWI occupant less than 16, and count 2 super drunk. Do you understand that?
Yes.
I can't hear you.
Yes.
Did you sign the advice of rights?
Yes.
Did you read and understand the rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. Do you have any questions on the rights form at all from me?
No.
All right. To the charge operating while intoxicated, how do you plead?
Guilty?
On October 29, 24, were you operating a motor vehicle on Jefferson near Slocum in the city of Trenton?
Yes, I was.
Did you drink alcohol prior to that? And if so, what did you drink and how much did you drink?
Vodka and probably a pint.
Okay. And was your ability to operate that motor vehicle significantly and materially affected due to the consumption of the alcohol?
Yes.
Why were you pulled over by the police?
Speeding?
You think you were speeding, at least in part because of your alcohol consumption?
Yeah.
Well, I don't want you to ask, do you think that's what happened?
Yes.
And did you take a breath test or a blood test ultimately?
Breath test.
And counsel, were the results, did you say 0.25?
Hold on 1 second, Your Honor, just to get it better. I think it's contained in that packet that I gave you. I think it's 0.25 or 0.27. Let's see here.
Actually, it's one was a 247, it looks like, and then a 250. You stipulate that was an accurate reading for purposes of the plea?
For purposes of the plea, yes.
Ma'am, are you on probation or parole?
No, I'm not.
Has anybody forced you to plead guilty?
No.
Okay, I'm gonna accept your guilty plea to OWI. I'm going to, I find it to be an accurate plea made voluntarily and understandingly. I'm gonna dismiss the super drunk OWI with BAC 0.17 or higher, as well as the OWI occupant less than 16. I'm going to refer you for a screening and assessment. You're going to fill out a questionnaire today, and then you will be interviewed today as well, and then you'll come back for sentencing with your lawyer, okay?
Okay.
All right. Lisa, has she been going to AA counsel?
Yes, she has, Your Honor. I have,
You've seen it, and she's been going 3 times a week?
she's been going more than 3 times a week, but she's been doing, she's got summaries of each of the hearings. She's been doing it via Zoom. So are you doing some in person?
I do some in person, but mostly Zoom.
But I told her you prefer in person, and she does already have a sponsor, and she's been doing substance abuse counseling as well.
So she's got proof that when she went in person, she got it signed. When she did it by Zoom, she at least wrote down something that was discussed.
Oh, yeah, I have a diary. She has
All
this
right.
journal, Your Honor.
The only thing I'm going to ask you to do in the meantime is go in person, okay, ma'am?
Yes.
Does she have any priors?
No priors, Your Honor.
All right, where does she work?
I don't.
She's a stay-at-home mother.
Okay. All right, screening and assessment. Give me a sentence date, Lisa, and we'll go from there, okay?
March 18th at 8:30.
Good with you?
1 second, Your Honor. I'm gonna be in Sterling Heights. Can we, let's see,
How
can
about
we do another day?
how about the 25th?
Yeah, that's,
I don't need this does not have to be a
if we could-
Tuesday. There's no restitution here. Why don't we do, how about the
How about the
17th?
31st?
Just flood. Just pull up, straight up? No, they dismissed the endangerment.
Hang on, how about the 17th? Can you do the 17th?
I can do the 17th at 10:30 a.m., Your Honor. Is that?
Are you gonna be here at 10:30?
Yeah, I'll be here at 10:30.
Okay, good enough. March 17th.
I just have a hearing in
That's fine.
Dearborn Heights District Court at 9. I'm assuming I can get.
Judge Pelosi and Judge Turfey are
Oh, they're
always on
both-
the bench on
Yeah,
time.
yeah,
March 17th at 10:30, okay?
that's fine, Your Honor. Thank you.
All right, so ma'am, you're gonna go down the hall, get your notice, over to across the hall to probation, fill out a questionnaire, and you'll be interviewed, and then you'll come back for sentence. Good luck to you. Thank
Thank
you.
you.
Thanks, Mr. Bulahanis.
Yeah, you're welcome. Thank you, Your Honor. You don't want to see any of her?
Not now. We'll take care of that at sentencing, okay?
Okay.
Thank
And then
you.
I do have a letter from who she's been seeing for substance abuse counseling.
Bernie Ball. How'd I know? I'll see you on the 17th. Thank you.
We'll see you.
I know.
Have a good day, Your Honor.
You too. Detective, do you have a case ready? With something?
No, Your Honor, I was just showing up for Mr. Dutton. He has a PCT.
Thank you. I appreciate that. Justin Horn. Justin Edward Horn. 2-4W-703-5751. Attorney Bates. Ms. Bates, good morning. How are you? Your name?
Good morning, Your Honor. Melanie Bates. I'm here for Justin Horn.
And where is Mr. Horn?
Your Honor, I have not had any contact with Mr. Horn. I did leave a message at the phone number that was on file for him. I just got the discovery, and sometimes they have additional contact information. Sometimes the phones are seized. So I'm not sure about his absence today.
Well, I'm going to issue a warrant if he isn't here. Do you want to check back in 15 or 20 minutes? Do you have another court to go to?
Yes, I can do that.
Check back. I'm going to issue a warrant for him if he doesn't show up, all right? Otherwise, I have no problem with your stipulation to adjourn. So we'll see you back here whenever you, anytime around 10 or 10:15 is fine with me, okay?
Okay,
I'll
sounds
keep your
good,
file
Your Honor.
right here. Thank
Thank
you. Have a
you.
good one.
You too.
Okay, your appearance?
Good morning, Your Honor. Mohammed on behalf of the people.
Sir, your name? All right, keep your voice up nice and loud, okay? And
Good morning, Your
Mr.
Honor.
Forrest?
Matthew Forrest, P73168, appearing on behalf of Darvion Stoudemire.
You can have a seat, Mr. Studemeyer. So I'm going to render my decision. If somebody has something else they want to say, go ahead and say it. Mr. Forrest, anything else?
No, Your Honor.
Mr. Mohammed?
No, thank you.
All right, so I had a preliminary examination on this case. That was back on a couple of weeks ago anyway. And the defendant is charged with possession of burglar tools arising out of an incident that occurred on September 9 of 2024 in the city of Woodhaven. There's a stipulation as to People's Exhibit 1, which shows some black keys and a programmer that was recovered by Officer Timmons after the stop. On the date of the offense, the defendant was a passenger, rear seat passenger, seated behind the driver's side, and the vehicle that was being operated by the owner's son, which is one of the co-defendants that does not have a case here, was traveling eastbound on Van Horn. The vehicle turned northbound, or what would have been left, onto northbound Allen. Officer Timmons observed the vehicle. It was at 1:45 in the morning, and he ran some vehicle information to discover that there was no insurance on the vehicle. He effectuated a traffic stop. There were 4 individuals in the car. Again, the defendant was seated in the rear driver's seat behind the driver. And at that time, what happened is the defendant was pulled out of the vehicle, as were the other occupants. There was a pat-down search of the defendant. Nothing was discovered. There were no admissions. However, there were some items that were located underneath the floorboard in a compartment. Officer Timmons observed or found in a latched-in area behind the passenger seat, underneath the floor mat, on the floorboard in a compartment, the programmer and a key. And that was opposite seat from the defendant who's here today, Mr. Studemeyer. Officer Cash came on the scene, and Officer Cash also located a key fob in the floorboard of the seat where Mr. Studemeyer was sitting behind the driver. So based on that, it appears, and based on the fact that the Dodge dealership was in the area, the officer had effectuated a stop. Now, he said he did it for insurance purposes because there was no, the defendant turned out to be unlicensed, uninsured. And when these items were recovered, the police called the tow company and placed the defendants under arrest. And the question is whether or not there's sufficient evidence to establish possession of burglar tools. Prosecutor says, well, it's a fact question. And because it was at his feet. The issue I have with it is whether or not there's any evidence with regard to knowledge of the defendant. There was no admission made by the defendant. There was nothing found on the defendant's person. They were not in the process of stealing vehicles. And I would simply say there was not enough evidence to establish dominion and control. There's no evidence that these were being utilized as burglar tools. I'll remind the prosecutor or anybody on appeal here that this defendant did not own the vehicle. There's no evidence he had any knowledge whatsoever of these items that were in a compartment. They were not in plain view. The items had to be recovered by manipulating that area to find that a key in the compartment area that was on the floorboard. It was below the seat. Again, no furtive gestures, no admissions, nothing found on him, no evidence that they were going to engage in this. You can't simply state because they're by a Dodge dealership. I mean, Allen Road is a heavily traveled road, albeit it won't be at 1:45 in the morning, but it's not like it's 7 miles away in a desolate area. So all in all, I cannot find that probable cause exists. There's just not enough evidence here to establish that he had possession, that he had knowledge. Like I said, and I think the defense appropriately pointed out, you can buy these items online. You can buy these items at AutoZone. That doesn't make them automatically burglar tools. I could go buy a hammer that could be considered to be a burglar tool, but if I'm not using it for that purpose to commit a B&E at the time, no way should it qualify, and it does not qualify as possession of burglar tools. Case dismissed for lack of probable cause. I think your client has other holes, does he not?
Yes, Judge.
Okay, because it looks like he posted here. Just give me 1 second, if you will. I'm just going to write this up. So I'm going to go ahead and dismiss. The bond is in the name of Monique Hearn. Who's that, sir? Mom. Okay, well, you tell your mom she can recover the bond on this case, okay? We're going to send you back to the county to deal with your other holds, but this case is dismissed. Thank you very much.
Thank you, Your Honor.
Good morning, Your Honor. It's Kirsten Ivan, P71920, on behalf of JP Graham and Salo.
I need you to start your video, please.
No problem, Judge.
Okay, there you are. All right. You're authorized to enter this plea. This could be a plea to overweight, and there's an agreement of $4,900 and $4,900 plus court fees, right?
That's correct, Judge.
All right. And you're authorized to enter this plea, as I said, correct?
That's correct.
To that charge of overweight, responsible or not responsible? On behalf of the company. All right, I'm going to accept the plea. I'll assess an additional $250 in costs. And that's $5,150 is the total, and that is to be paid by the 28th of March, okay?
All right, thank you, Your Honor.
Have a good day. Thank you.
Bye-bye.
Call the case. Solomon Knighton. Solomon Wesley Knighton, 24F163669. He's got it written down on the your appearance.
Good morning, Judge. Deanne Patillo, P82378, on behalf of Mr. Solomon Knighton.
Your name?
Solomon Wesley Knighton.
Ms. Did you deal with Ms. Aloy?
I did. We had conversations about 769, so that's not what we're asking. I don't know if it was an error.
Well, she wrote it on the wrong sheet. That's all I'm asking, or the wrong place. Can we call her in 236? Ms. Aloy, can you come in here, please? Can you hear me? Call 236.
She said she was on Zoom.
Oh, okay, yeah, Judge, thanks, bud. She's on.
she didn't do anything wrong. She just wrote it in the wrong. This is like the deferral area. So this can be a straight up plea to domestic, right?
Yes.
Counsel, good morning. Can you come up and tell me your name, please?
Nor Ali on behalf of the people.
So if this is just a straight up plea, it should be up here. It would just be pleads guilty under 4, not under 6.
Okay, I wasn't aware of that.
Can you just change that? You can cross out what's on number 6, and you can add it to number 4, pleads guilty. All right, Mr. Knighton, do you understand what's going on here?
Yes.
You're being offered the opportunity to plead to domestic violence. I just want to check one thing here.
And will you request the pre-sentence investigation?
Sure.
Okay, after that, if we did also discuss HIDA, if you see the pre-sentence investigation.
I'm not doing it.
Consider, no.
I'm sorry. The statute's clear. You can do it under 7694A. The fact that they did it under HIDA once doesn't change anything to me. You can't circumvent statutes. Otherwise, somebody could do it under HIDA, then they could do it under 771.1. I'm sorry. If you plead guilty here, sir, the possible penalties there are up to 500 fines, 93 days jail, costs, or all of those. Do you understand that?
Yes.
And you understand those recommendations are just that. They're just recommendations, correct, counsel?
Yes, Judge.
And you agree with that as well, correct?
Yes, Your Honor.
Just recommendations. They're not part of a sentence agreement, correct?
Yes.
So if I don't, all right. And did you sign, read, and understand the advice of rights form, Mr. Knighton?
Yes.
If you understand you plead guilty, you'll be giving up all of the rights on that advice of rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. You fully understand everything on your advice of rights?
Yes, I do.
Any questions for me?
No.
To the charge of domestic violence, how do you wish to plead?
Guilty.
Were you on December 20 of 24 at 25811 Valley Creek Drive, apartment 1106 in Flat Rock?
Yes.
And what was your relationship at the time with Natalie Brown?
Girlfriend.
Were you residing with her at the time?
Yes.
And okay. And what did you do?
Pulled her by her shirt out of my house.
I'm sorry?
Pulled her by her shirt out of my house.
You dragged her out of the house?
I pulled her by her shirt, directed her out of my house. And when I did that, I called the police to come to the house. And when I did that, they was outside and seen me dragging her out the house and trying me with assault.
All right. You called the police?
Yeah.
And then you were pulling her by the shirt out of your unit on Valley Creek Drive, correct?
Yes.
You wanted her to leave, obviously.
Yes.
And then the police showed up?
Yeah.
And they wrote you for domestic?
Yes.
Are you on probation?
No.
Parole?
No.
Anybody force you to plead guilty?
No.
Plea is accepted to that charge of domestic violence. Have you been printed in accordance with this case?
Yeah.
You were printed that night?
Yep.
Was there any alcohol involved? Can either one of you tell me, or drugs?
No.
There were no drugs or alcohol involved, Judge.
All right, pre-sentence report, I'm going to order sentence date, and then you'll come back for sentencing. Lisa, when do you want to do this?
March 18th at 8:30.
Is that good with you?
Yes, Judge.
March the 18th at 8:30. So you're going to take him down the hall. He'll get his notice. You can get a notice, and then you'll go across the hall to be interviewed by probation. Any questions?
No.
Anything else, Ms. Louie?
Nothing.
Am I pronouncing that correctly? I keep asking you that.
I say Aloe.
Aloe. Aloe. I'm sorry.
Okay.
My mistake. I keep looking at that and I knew. Okay, thanks. Have a good day.
Thank you,
Good
Judge.
luck, sir.
Was the form correct when you?
Yeah, the way you've done it now is fine. You just want to,
I didn't see that.
the 6 is all the deferred statutes, 769, 771, HIDA, et cetera, okay? All right.
Thank you.
Thank you very much. All right. Good morning, Ms. Bates. Again, Justin Edward Horn, 24W7035751. Good morning, your name?
Good morning, Melanie Bates, P76080, appearing on behalf of Justin Horn.
I'm told your client is in Livingston County, so we're going to reschedule. Can we set this for a PCC next week and then the exam the following week if it doesn't resolve?
Let's see. My law partner is going to be in Tennessee, and I'm going to be by myself on the 11th, and I am completely at capacity. Can we do the PC on the 18th?
I'll do the PCC on the 18th and the exam the 25th, but no more adjournments, okay?
Okay.
So March 18th, we'll make the PCC at 10 a.m. and the preliminary exam will be March the 25th at 10:30, okay? And that will be in person.
Okay.
But we're gonna have to writ your client out anyway, so I'm sure they'll put him on front of the camera unless he's been released from Livingston by the 18th. I don't know what he's there for, but.
Yeah, so we have 318 and 325 at 10:30.
The 318 is at 10 o'clock.
10 o'clock, okay.
Have a good day. Thank you.
Thank you, you too.
John Grant Dutton Jr., 25T703059.
Michael A. Carmen, P73824, on behalf of the defendant, Your Honor.
Sir, your name?
John Grant Dutton Jr.
Jeez. I don't want to adjourn this too much longer. Everybody's asking for adjournments here. What do you need to do here?
Your Honor, we requested, I guess you'd call it a deviation plea, and Mr. Muhammad says he's got to talk to a supervisor about it, but.
He's got a fourth offense notice, your guy, right?
Yes.
I'm going to move it along, though. I'll give you an adjournment to March the 11th, PCC, and then preliminary exam on the 18th. This has been going on since February the 13th.
Understood, Your Honor.
So PCC will be March the 11th at 10 a.m. Preliminary exam, March the 18th at 10:30.
We already had it set for 10:45 on the 18th.
Okay, 10:45 on the 18th. Okay.
Thank you, Your Honor.
So you guys can work at that and try to resolve it. If not, we'll go in a couple weeks. All right. Sir, go down the hall, get your notice, and you're all set. Wish you well, sir. Good luck. Elizabeth Martha Hodges at 25B703140.
Michael A. Carmen, P73824, on behalf of the defendant.
Good morning, ma'am. Your name?
Elizabeth Hodges.
All right, we're going to adjourn this a week or so.
Yes, Your Honor.
Okay. Well, this is a pretrial. Let's make this the 18th. We'll make it the 18th, Lisa, at 9 o'clock. Is that good?
Yes.
All right, March the 18th at 9 o'clock. Any questions, ma'am?
Your Honor, I would like to address a bond condition.
You're going to have to call in Ms. Alloway, John.
Okay. This is Mr. Muhammad's case.
Oh, it's domestic?
Yes, but it involves her child.
Okay. Okay, call in Mr. Muhammad. Did you tell him you were going to address bond?
No, I just discussed this with my client 2 minutes ago.
Ma'am, come on up to this podium a little bit closer, okay? So I'll go ahead and get Mr. Muhammad in here and you can address it then, all right? Set the bond in this case. I did. Mr. Muhammad, your appearance?
Good morning, Your Honor. Mohammed on behalf of the people.
He wants to address bond.
Okay, which case is this?
This is on Elizabeth Hodges. It's a domestic charge. Okay.
Your Honor, it's my client's understanding that the no contact order extends to her daughter, her minor daughter, Mia Paul. I don't see her listed as a prosecution's witness on their witness list that was provided to me in discovery. She has not talked to her since this incident a few weeks ago.
I only have a Mason Paul written down here.
Okay, my client indicated to me that she was told there was no contact with Mia, her daughter.
Is Mason Paul a victim here?
He's the complaining witness, Your Honor.
Well, that's all that was ordered, and I believe I might have done this. There's no, I didn't set any, let me just double check one thing. No contact with Mason Paul or prosecution witnesses. No firearms, no dangerous weapons.
No, Your Honor, and we just confirmed that Mia Paul is not a prosecution witness.
Okay, well, what are you looking for me to do? Is that true, Mr. Mohammed? Is Mia Paul a witness?
No, she's not.
Well, then, yeah, there's no order that she can't have contact with Mia Paul. Is that a daughter?
Yes.
And Mason Paul is who?
My son.
Yeah.
Okay, just wanted that clarified, Your Honor.
Yeah, she just has to be careful how she's having contact. She can't go over
Can't
to the
discuss
house
the
and
case. Yes.
talk to Mason Paul or run into
Correct.
Mason Paul, okay?
Okay, thank you, Your
All
Honor.
right, good luck. So go down the hall, get your notice. Best of luck. Alan LePage. Alan Michael LePage, 25W703417.
Michael A. Carmen, P73824, on behalf of the defendant, Your Honor.
Good morning, sir. Your name?
Where? Right to the podium.
Walk to the podium.
How you doing?
Morning.
Your name?
Your Honor, I'm deaf, so
Oh, I'm sorry.
I'm deaf and legally blind, so work with me, please.
I'm sorry. Can you hear me all right?
I can hear you now.
Tell me your name, please.
Alan LePage.
We're going to go ahead and adjourn this case, okay?
Okay.
We're going to adjourn it for how long do you want, Mr. Carmen? I can go to the 18th.
That's fine, Your Honor.
March the 18th will be your court date.
Okay.
And that will be at what time, Lisa?
9:15.
At 9:15. Okay?
Yes, sir.
9:15, and you can go down the hall and get your notice, all right?
Yes, sir. Thank you.
Thank you. Is that Mr. Strong? Mr. Strong, what are you going to do on that case, sir?
Judge, I need to talk to Mr. Gartenhire. Have had no contact with him.
He's not on Zoom.
He's not here?
He's not on Zoom. I'm not sure if he's in person.
He did not check in with me. He's not here.
Was there a personal bond, Mr. Strong? Do you remember?
It is, Your Honor, and on the appointment sheet, there's no phone number and the address.
He's not here, I'm told. So what time was that scheduled? Yeah. I'll just issue a warrant for him. I'll get you out of here. I'm sorry. If you can get a hold of him and,
Yes, Your Honor.
okay, people against Marcel Gardenhire, 24W70643. Okay, Mr. Strong, your appearance?
Yes, Your Honor. Ronnie Strong appearing on behalf of the defendant.
All right, well, I'm sorry. He failed to appear for PCC. It was scheduled at 9. He was given a personal bond, so he's not in custody. Bench warrant to issue, bond to be forfeited. 30,000, 10% will be the new bond. And I'll just make a note, I called the case at 10:23. Have a good day, Mr. Strong. Take
All
care.
right. Thank you, Judge.
Let me get to whoever the probation, let's see, this is Ms. Tacino. Can you call her in?
Yes, sir.
Sean Christopher Miller, file
Yes, sir.
number 24B146046A.
Ready, Your Honor. Good morning. May it please the court. Derwood Haynes, on behalf of Sean Miller. I believe we are here for sentencing, and he pled to this violation last time we were here.
So it was January 30, and he pled to failure to report, failure to attend 2 days on the court work program, failure to provide verification with attending and completing intensive outpatient treatment with aftercare, and then also failure to report to probation within 24 hours of release. So I revoked his status, entered the conviction. My issue here was there was $4,500 in restitution. Has he made arrangements to pay that? I'm not.
Judge, let me back up a little bit, and I know you have a great memory for all
No,
of
I
these
don't.
things.
Go
But
ahead.
Mr. Miller, who I think he's in his late 50s now, but I think till he was 56, had no criminal record. He got hooked on opiates and ended up stealing, in this case, stole some jewelry to sell it, to get money to buy drugs, and that's the spiral he was in. Kind of remained in that when he absconded from everything and didn't turn up again until I think just before the new year. He has a pending case in Beverly Hills. There might be a warrant out on that. But the reason we put this over till today was because he got sentenced in Monroe County yesterday, and we wanted to see what happened with that. What they did was he ended up just getting a 90-day jail sentence, credit 54 days. His out date is March 24th. By trade, Mr. Miller is a truck driver. Right now, he has nothing, everything, what during his drug use, he lost everything. But he, I think, is one impeding traffic ticket away from getting his CDL back. His former companies would take him back to work, and he says, we kind of rounded it out, probably makes about $5,000 a month when he's working. He has a restitution issue in that Beverly Hills matter too. We're thinking that he could, if he got back to work, he could get everything paid off in 6 to 9 months, but he's got to get back to work. So what I'm going to end up asking, and I know we have to hear from Ms. Tessino too, is that we get his probation extended so the court keeps jurisdiction over him with probably some of those pretty obvious conditions, and allow him to go back to work and pay this restitution.
Okay, so he was only sentenced here on July the 17th of 24, so we do have time. Your name?
Evelyn Tessino.
So he's got 36 more days to serve on the one case.
No, well, I mean, technically, but his out date is March 24th, so we're 3
Okay,
weeks before he gets out.
statutory good time credit and whatnot, and then he's got the other case in Beverly Hills that's scheduled for what?
We don't know. He's not able to get information. He has another attorney who's dealing with the Monroe case, who I had spoken to a couple months ago. He's going to be looking into that to see if they're going to hold him post March 24th, or if they're going to do something similar and extend him and allow him to pay that restitution, which he's not sure, because again, he can't get much information, but he's ballparking that at about $5,000.
I think what I'd like to do, you're going to be here, let's see, today's the 4th, 11, 18, 25th, right?
We're looking when I'm going to be here again.
You should be on.
So I've got your probation violator docket March 31st. I don't know if that's a good day.
What day of the week?
That's a Monday. I'm also here that Friday, April 4th, doing arraignments, and I've got overflow the next week on the 9th and 10th. So
I think I want to just sentence him under the, revoke the status.
Yeah.
But I think I'll sentence him March the 31st. Mr. Miller, I would like you to bring all your paperwork to court on that day, and I want you to appear in person, okay?
Yes, sir.
So I'm going to set a sentence date for March 31. Am I okay that day, Lisa? I mean, I know I got civil or whatever, but.
No, it's actually your probation day. Mr. Haynes.
Well, good. Good. Then let's do this at 9 o'clock in the morning. You show up that day, Mr. Miller. Bring me your paperwork from Monroe and anything that you might have paperwork wise from Beverly Hills, okay?
Yes, Your Honor.
And I'll talk to you. We'll set the sentence date for that date. I don't need another pre-sentence report, but if you can get that paperwork to us a couple days before, not originals, but copies, I can at least look at it. All right?
I'll do my best, Your Honor.
I would just ask Mr. Miller if he's in custody for some reason because of the Beverly Hills matter, if he could just have his attorney call me.
Yeah. Did you hear what your lawyer said? If somehow you're in custody in Beverly Hills or any place else, have the lawyer representing you there call Mr. Haynes, okay? And advise him so we could have you, so we can put this on Zoom or reschedule or whatever else seems appropriate at the time, okay?
Mr. Haynes at the 33rd District Court will do.
Well, he's not at the 33rd. He's here today. He's House Counsel. He's MIDC attorney, but
your other attorney has my number.
Okay.
I'll watch it too. Like a week before, I'll check it.
Yeah, so try to let us know, Mr. Miller. Thank you very much. We'll see you on the 31st. Good luck to you. Have a good day. Thanks, Mr.
Thank you, Your
Haynes.
Honor.
You're welcome. Mr. Collins, what case do you have, sir? Is
Judge,
that,
I have, I think it's Venetia Bell. I just got it
okay.
yesterday.
People against Venetia Renee Bell, 24M710670. Where is Ms. Bell? There you are. Ma'am, your name?
Venetia Bell.
And good morning again, Mr. Collins, your appearance?
Good morning, Judge. Harold Collins, P56805, on behalf of Ms. Bell, who is present in the courtroom, Judge.
Okay, what are we doing on this one?
Judge, I am just, the prosecutor's just sending me discovery. We'd asked to go out a couple weeks to come back with a adjourned PCC, and I need some contact information from Ms. Bell.
All right, so how about if I adjourn the PCC to the 18th and the exam to the 25th? You available both those days?
I am.
Yes, Judge, I can make it happen.
All right, ma'am, do you understand what your lawyer is saying here?
Yes.
All right, so he's telling me that he needs more time to prepare, and he's asking for an adjournment until the 18th of March. If I grant that request, that means that the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
I do.
And you have that right to have the probable cause conference within 14 days of the date of the arraignment. Knowing that, do you wish to waive that right so that your lawyer can better prepare?
Yes.
Anybody force you to give up that right?
No, sir.
All right, I'm going to accept that waiver. We're going to set it March the 18th, Lisa, at, am I doing 10?
Yeah, 10's fine.
And then on the 25th at?
10:30.
So you have to be here in person on the 25th, ma'am, and you have to be here on the 18th at 10, okay? So March 18th at 10, March 25th at 10:30, and maybe, Lisa, you can put the two of them in a breakout room so we can get her contact information, okay?
Thank you, Judge.
Have a good day, Mr. Collins. Good luck to you, ma'am. We'll see you in a couple weeks. Thank you. All right.
Thank you.
People against. 1 second here. All right. People against Andrew Scott Scardarazzi, file number 25B710359. All right. Good morning, everybody. Your name?
Good morning, Your Honor. Nora Ali on behalf of the people.
Neil Rockine on behalf of Andrew Scottarassi.
Good morning. And your name, sir?
Andrew Scottarassi.
All right, today is the date scheduled for a preliminary examination. We have 3 counts, but the third is a misdemeanor. So we're going to proceed to exam on count 1, felonious assault, and count 2, felony firearm. Any preliminary matters, either one of you? Ms. Holloway?
Just a mutual sequestration order.
All right, I'm going to order all witnesses with the exception of the officer in charge and the defendant have to leave the courtroom immediately. So all witnesses in this case, with the exception of the officer in charge and the defendant, are to leave the courtroom. He what?
I was just saying the detective is on his way.
Okay. Any other preliminary matters?
No, Your Honor. Thank you.
Okay. Call your first witness, please.
The people call Chantel Scardarassi to the stand.
Okay. Ma'am, you can come right up here, wherever she is.
We need to go grab her.
None of these are witnesses back here either for today or the time of trial, correct?
No,
Not to my knowledge.
Okay. You can call, go get your witness if you would. Is somebody getting her?
Yes.
Okay. Lisa, I thought you said I had one more case besides this one. Am I wrong?
Yeah, there's a Randy Schumacher, but they're not on Zoom.
Okay.
He hasn't checked anything.
I'll deal with that after. Ms. Scotterossi, you can come right up here. I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
I do.
Okay, have a seat, please. I'm going to ask you to keep your voice up nice and loud for all of us, okay? And speak direct into that microphone if you would. And is your first name spelled Chantel?
Yes.
Middle name Anne, Anne?
Yes.
And the last name again is Skardarasy, correct?
Yes.
You can proceed, Ms. Holloway.
Good morning. Could you please state your name for the record?
Chantel Skardarasy.
Ms. Gardarasi, I'm going to take you back to April 10th, 2024. Do you recall that day?
Yes.
Did something happen on that day that brings you to court today?
Yes.
Can you tell me about what happened starting from the beginning?
I was attacked by my husband.
Okay, so I'm going to stop you there. You said your husband. What was his name?
Andrew Skardarasy.
Okay, and do you see Andrew Skardarasy in the court today?
Yes.
Okay, and can you identify him by telling me the color of the shirt he's wearing?
Blue.
Let the record reflect that the witness has identified the defendant.
The record should so reflect.
Okay, so you said he attacked you. Can you tell me, where were you on this day?
I had come to his house at
Okay, and where is his house located?
25801 Chelsea Creek Lane in Brownstown.
Okay, is that city of Brownstown, county of Wayne?
Yes.
So tell me what happened when you got to the house.
I came to the house. I turned off the cameras so that the phone wouldn't go off. I needed to get a code off of his phone or his laptop.
So let me stop you there. Were you living in the home at this time?
I had been separated for a week at the time.
I'm sorry, separated for what?
We had separated a week earlier, so I was staying with my mom.
Okay. Did you live at this home prior to that week?
Yes.
And were you allowed to go in, come and go to the home as you pleased in this week that you were separated?
I apologize, Your Honor. I'm just going to object to the question about what she allowed. She can say what she believed, but they're separated and he was living.
All right, rephrase your question if you would. Was there any agreement between the two of you as to whether or not you were going to go back to the property or could go back to the property?
He was trying at the time to get back together. So yes, in the mornings I would get the kids ready for school and I would go into the house after school and get their things and take them home.
Okay. So tell me what happened after you had got to the home.
So I got his phone. I drove down the street to try to get a code sent to it without him waking up. I was afraid of him waking up.
Wait a minute. I'm getting old. You got to keep your voice up, okay?
I'm sorry.
You got his phone, and then what?
So I drove down to Kroger in the parking lot to try to get a code sent to his phone. There was spyware put on my laptop. I'd asked him to take off. And in order to get it off, you have to have a code sent to either an email address or a phone. So I was trying to get that.
And so let's just go back for a second. I want to know, what time did you first go to the home?
Midnight, around midnight.
It was around midnight. And then what time? So when you went in, did you grab his phone?
I did grab his phone. I tried his laptop first.
Okay. And then did you leave?
Yes.
And where did you go?
Down the street to the Kroger parking lot.
Okay. About how long were you there?
About 10, 15 minutes.
Okay. And then what did you do next?
I drove back to the house and brought the phone back.
Okay. Tell me what happened when you got back to the house.
He was awake. He was angry. He accused me of taking money of his.
Okay. And when you say he, who do you mean?
Andy.
Okay. Was anybody else in the home at this time?
No.
Okay. So tell me what he was saying to you.
He accused me of taking his money. I said I didn't take his money, but I had his phone. And I walked through into the kitchen and tossed it on the table.
Okay. And tell me what happened next.
I walked back through, there's a gate that separates the front room and the kitchen. So I walked back through the gate and I shut it.
Okay, and I just want to get a clearer picture. You said there was a gate separating the kitchen and where?
The front room, like the foyer.
Okay, and is the foyer, is that right at the front door?
Yes.
Okay, and so tell me what happened when you got out of the kitchen.
I shut the gate. He kept asking me where his money was. He walked to the end of his kitchen table and picked up his gun.
Okay, and I'm gonna stop you there. Did you see a gun there prior?
Yes.
Okay, and so tell me, what did he do next?
He picked up the gun. He walked towards the gate. I made kind of a joke, like, "Are you gonna shoot me?"
Okay, and I'm gonna stop you again. About how far were you and the gun?
Probably from me to you at the time. It was on the table that far away.
Okay.
So what would you say? That's about 20, 25 feet?
I
want to say it's 15.
It's the length of a kitchen table. I mean, I know, I'm probably the table was that long, and then there was the gate and me.
Okay, so you tell me, can you estimate the distance?
I would say about 15 feet, if I had to guess.
And so, tell me what happened. What happened next?
He walked through the gate. He stared at me for a second. When I asked him if he was going to shoot me, he said yes. And then he grabbed me from the back of my hair, pushed me up against the closet that was behind us.
Okay. And so where is this closet located?
So it's directly in the middle between the kitchen and the foyer. It's right next to the gate.
And so tell me what happened next.
He had his pistol in his hand and put it underneath my chin.
Okay, so I'm going to stop you there. Do you remember what this pistol, as you said, looked like?
Yes.
What color was it?
It was black.
Okay, about how big was it?
About this big. It was a 9mm Smith & Wesson.
What is that? About 4 inch, 5 inches, 4 inches?
About 5, I would say.
Okay, and to your knowledge, was that his gun?
Yes.
And did he point it at your neck?
Yes, under my chin.
Under your chin. What part of the gun was on your neck?
The barrel, the top of the gun.
Okay. And did you observe at all if his finger was on the trigger?
Yes, as he was bringing it to my neck, I could see it.
So tell me, what was he saying to you in that moment?
He said, "Give me my," can I swear?
You should quote exactly what he said.
He said, "Give me my fucking money." And I said, "I don't have your money." And he said, "I'm going to fucking kill you." Very calmly.
And at this time, when you were up against the closet, was his hand still on the back of your head?
Yes.
Was he grabbing your hair?
Yes.
Okay. And so tell me what happened next.
I just stared at him while he was saying those things and said, "I don't have your money." He told me, he said, "I'm going to kill you." And then he said, "Do you know who else I'm going to kill?" And then he turned around, looked up at our kids' bedrooms. There's one on one side of the upstairs, one on the other. And he looked at me and said, "Everyone," very quietly.
Okay, and then what happened next?
I got kind of smart mouthed and said, "You better hope so."
Okay. And how were you feeling in this moment?
I was scared and angry.
And were you in fear for your life at this time?
Yeah. Yes.
So tell me what happened next.
He held it there for a second. And then he was wearing gray sweatpants at the time. He took the gun down from my neck. He put it in his waistband of his sweatpants while he was laughing.
And what did you do next?
I just watched him slowly put it in his waistband.
And then what happened?
So he slowly put it in his waistband, and then he looked up at me, and then he pretended like he was going to punch me in the face. Stopped about 1 inch from my face.
Tell me what happened next.
The dog got really excited from the other side of the gate, pushed through the gate and jumped up on him We had a Rottweiler, so he was pretty big.
And what did he do when this happened?
It knocked him down, and that's when I turned and ran out the door.
When you ran out the door, what did you do?
I called the police and went to my vehicle.
I'm sorry.
I ran to my car and called the police.
So did the police arrive?
No, I drove to the police station.
At the police station, which police station was it?
Brownstown Police Station.
And when you got there, were you able to speak to an officer?
Yes.
Did you tell them what happened?
Yes.
Did you write a statement?
Yes.
Did you? Actually, I have no further questions, Your Honor.
Okay. Cross.
Ready for me? Absolutely. I'm going to call you Ms. Scatarassi. Is that okay?
Yeah.
Did I pronounce it correctly?
Yes.
Contrary to the judge's own self-derogatory comment, he's not getting any older. So he hasn't lost a wink of hair. He hasn't gained a single wrinkle in all the years that I've been in front of him. So, Ms. Scatarassi, I'm going to ask you some questions, okay?
Okay.
So let me start with going back to the date of this incident. You were April 10th, right?
Yes.
You were married at that time, correct?
Yes.
But separated, right?
Yes.
Now let's talk about separation for a moment. When I say separated, prior to your official separation, you and Mr. Scatarassi had been living together. Is that correct?
Yes.
And then one of you moved out, right?
Yes.
You moved out.
Yes.
You went to go stay with your parents.
Yes.
And you were staying with your parents on the date of the incident. Is that correct?
Yes.
Okay. Let's talk a little bit about, let's fast forward to your conversation with the police department on April 10th, okay?
Mhm.
So you have to say yes or no. Those aren't my rules. Those are just in order to make the court reporter able to type down what you say. Do you understand?
Yes.
When you went to the police department on April 10th, you walked into the Brownstown Police Department. Is that right?
Yes.
Now, you understood, you were there to tell the police department what you say occurred. Is that right?
Yes.
And you understood it was important to be truthful with the police. Is that true?
Yes.
And you understood how important it was to tell them an accurate account of what you say took place. Is that right?
Yes.
And you understood it was important to tell them all parts of the story, no matter the good, the bad, and the ugly. Is that fair to say?
Yes.
And the officers actually spoke with you. Two officers spoke with you, I believe, out in the lobby originally, correct?
I believe so.
And then they asked you to write out a written statement. Is that right?
Yes.
And you were truthful with the police. Is that what you're telling us?
Yes.
Yes?
Yes.
And that you were truthful when you wrote out your written statement, correct?
Yes.
Now, when you wrote out your written statement, I'm just going to, may I approach the witness for a moment, Your Honor? Ma'am, may I? I'm just going to show her a written statement, just to verify what this is. May I approach you, ma'am?
Yes.
Okay. I just asked that just so I don't startle you, okay?
Okay.
I just want to verify, I'm not seeking to admit it. I just want to verify that, just take a look. What this looks like your statement, it's 2 pages. Just take a look at that and make sure that's the correct statement. Is that it? And you signed it at the bottom, is that correct?
Yes.
And you didn't just tell part of the story in your written statement, you told exactly what happened, is that right?
Yes.
Okay. So let's go through if we could. Now, prior to April 10th of 2024, the day or night of this incident, you had actually been anticipating, again, I don't want to know what you and a lawyer talked about, but you had been anticipating filing divorce. Is that correct?
No.
You had not spoken with a divorce lawyer. Again, I'm not looking for content. You had not spoken with a divorce lawyer prior to April 10, 2024?
Okay, yes.
You had, correct?
Yes. Mhm.
All right. And Mr. Scatarassi on April 10th owned a business, didn't he?
Yes.
And he's 100%, he's the only shareholder, the only owner of the business. Is that true?
Yes.
Am I correct?
On paper, yes.
Well, that's all there is. He's the owner, correct?
Correct.
Now, when you ended up going to, on April 10th, and let me be real clear, you went to the house, right?
Yes.
To his house,
Yes.
And let's go through and talk about the things that you did in preparation for going to the house, okay? He has a business. Where's the business located?
In Ecorse. I'm sorry, in Romulus on Ecorse Road.
Okay, you just keep your voice up. I don't know.
In Romulus on Ecorse Road.
Thank you.
And I think it may be easier if you, I think that microphone actually amplifies, doesn't it, Judge?
Yes, it does.
So I think it may be easier if you talk right into it, okay?
Yep. Yes.
So the business is in Romulus, right?
Yes.
What's the name of the business?
Silver Touch Landscaping.
Silver Touch Landscaping. Now, it's a landscaping business, yes?
Yes.
It's not open at midnight or 1 a.m., is it?
No.
Objection, Your Honor. I understand where he's trying to go. I think this is a bit out of the scope of the testimony. He needs to speed this up and get to the point.
Overruled.
Thank you. You actually went to that business, didn't you?
Yes.
You went to that business prior to going to the home, correct?
Yes.
Now, and when you went to the business, you actually, the business wasn't open for business at midnight or 1 a.m., was it?
No.
And you didn't tell Mr. Scatarassi that you were going to the business that was closed at 12 or 1 a.m., did you?
I don't believe so.
Right, because you were trying to sneak there.
Yes.
You were trying to be secretive,
Yes.
clandestine,
Not sure what that means.
means secretive.
So yes.
Okay. You went to the business, you entered into the business with, I presume, a key of some sort, correct?
Yes, my key.
And you then attempted to, again, you have a key to the business, yes?
Yes.
But your key to the business is to allow you to access the business to do certain things. Right? Like there's things you can do that are authorized and things that you can't do that are authorized.
No.
So you could go there and you could just tear the place apart if you wanted.
If I wanted to.
So you believe you could go there at midnight or 1 a.m. and you could just throw all the computers out, throw all the paperwork out, you could burn the place down, and that would be within your authority.
I believe that's illegal, so no.
I'm sorry?
I believe that's illegal, so
Right,
no.
we're gonna talk about that in a second. So you did some booking and paperwork for the business, is that right? Some billing and paperwork, right?
That and some more, yes.
That and
Wait,
some more.
I didn't hear that.
That and some more,
Okay.
yes. Sorry.
Now, the reason why I asked that is that you went there at 1 a.m. And you gained access to the building, to the office. Yes?
Yes.
You sat down in front of a computer. Yes?
Yes.
You turned the computer on, right?
Yes.
And then you actually sat down and tried to do things on the computer for yourself,
Yes.
not for the business, but for you personally.
Yes.
What'd you try to do on the computer at that point?
I tried to get the code for,
Right, but tell me
Security
specifically,
code.
you had to type in a password or something to access the computer, correct?
yes.
Did you use your own name or do you have to use like a name and code to enter the access to the computer?
I used my login.
You used your login after hours when it was closed.
Yes.
And then you attempted to gain access to this computer. Now, is there anything that says that you were able to go to the business at 1 a.m. to attempt to access the business and the computer? You have the authority to do that?
Yes.
What is there that says you have the authority to do that?
Text messages from my husband.
Okay. So you texted him that night to say, can I go to the business at 1 a.m. and access it and access the computer?
Can I?
I just want to know if you have a message from that night.
Sort of, yes.
You do. You have a message from that night.
Saying I needed the code and I was going to get it.
Wait a minute, saying that what?
Saying that I needed the code and I was going to get it. I didn't specify where though, if that's
Right. You didn't tell him you're going to the business.
No.
Just like you didn't say you're coming to the house.
No.
Just like you didn't say you're going to actually access the computer after hours.
Right.
Just like you didn't say you're going to actually attempt to take his phone.
Right.
Just like you didn't say you're going to actually attempt to access his laptop.
Right.
Let's talk about those things. So after going to the business and attempting to gain access to this computer, you were unsuccessful in that way, correct? You weren't able to gain access to what you wanted to or what you needed to, correct?
Correct.
You then left that business. Yes?
Correct.
What time did you leave the business?
I can't remember the time.
By the way, when you asked Mr. Scatarassi on the phone to access the computer, or you needed the code, did he say okay?
At one point, yes.
At one point. He didn't say, go ahead, come get it from me, or go to he didn't tell you that it was okay to do any of these things that I just went through, did he?
No.
You then left the business, and what did you do? Where did you go from there?
To his house.
To his house. And what'd you do when you got to his house?
I turned off the cameras and tried to get the
Let's
code.
pause for a second. You actually monitored the security system at his house, correct?
Correct.
Where were you sitting when you were monitoring the security system at his house?
Sitting?
Yeah, where were you?
You
were in your car.
No, I don't have access. I didn't have access at that time.
Where did you have access? How did you access the security system and how are you monitoring?
Oh, wait, no, the kitchen one. I did. Yes, I had the kitchen one. I'm sorry. I
kitchen
was
one.
from my car. Yes.
You were sitting in your car monitoring the kitchen.
Yes.
And you were monitoring the kitchen camera because there's a kitchen camera that actually looks out over the kitchen and the living room, correct?
Correct. Yes.
How long did you spy? I'll call it that. How long did you spy on Mr. Scadarossi and the interior of the home?
I looked while I was at the office to see if he was sleeping.
So you were, I mean, that's further, I'm going to call it secretive, spying, sneaking, right?
Yes.
And what were you looking for?
I wanted to see if he was sleeping, so I could
Because
get
you
the
wanted to
code.
go to the house and not let him be aware that you were attempting to sneak or enter into his house without his knowing, yes?
Yes. Yeah.
So you went from one place where you snuck in, which is the business, and then you went to the house and you were monitoring to see if you could sneak in there.
I wouldn't say sneaking in. I was allowed access at all times.
Well, I know that's what you're saying now, but we'll talk about that in a second. You didn't just walk in at midnight or 1 a.m.
No, I used my key.
Right, let's talk about that. You then, you actually, you were monitoring his behavior, yes? You're
His-
watching him on your phone,
Yes, I checked to see if he was sleeping.
right? How many times?
A few times, I would assume.
And then when you determined that he was sleeping, you then walked up to the front door. Tell me how you walked up to the front door of the house.
I walked up and I took the Ring camera off.
Let's be a little more detailed because that's not an entirely accurate description of what you did, is it?
Well, when you walk by the Ring camera, it alerts your phone and it starts ringing.
So what did you do? So let's be honest. Let's just not tell half the story.
Mhm.
That was not a complete rendition of what you did to attempt to hide your approach to the house, was it?
No, I stepped up onto the porch from the side and I took the
Right, so
Ring
show
camera
us,
off.
there's a pilaster or a pole, correct? It's
Correct.
a pole, like a column,
Mm-hmm.
yes?
Is that a yes, ma'am?
Yes.
And what
Yes.
what you did was almost like out of a movie.
I wouldn't say that. I wasn't
Well-
very stealthy. I saw the camera footage.
You were pretty stealthy. You tried to be stealthy.
I tried not to alert it as many times as I could.
We can distribute your purpose, but you tried to be stealthy.
Sure. Yes.
And what you did is you walked up to the column or the pole and you tried to hide your body behind the pole or the column, right?
I stood next to the Ring camera and I took it off so that I wasn't alerting the Ring camera.
Just answer my question if you could. Did you stand next to the column and try to hide your body with the column?
I remember leaning against the house so that I could take the Ring camera off. I can't remember exactly where I was standing.
There's a column there, isn't there?
Like a pillar? Is that what you're
Yeah, the
talking
column in
about?
front of the house, yeah.
Yeah, it holds up the porch.
Yeah, right. And that's what you stood behind.
I remember standing next to the Ring camera. I would assume that's where I was standing. I'm not sure though.
So, Judge, can you hear okay?
I'm sorry. I assume that's
Still
where I was standing. I just remember specifically standing next to the Ring camera to
Just
take it
keep
off.
your voice up for me, okay?
Okay, I'm sorry.
And what you did then was you actually had your phone in your hand, watching the interior of the house.
I don't believe I did when I was up on the porch, but I could have.
You then attempted to reach up to the Ring camera, right? And you attempted to pull the battery out.
I took the battery out, yes.
Yeah. I'm just gonna ask you a very direct question. Did Mr. Scadarossi tell you at that time that, we'll strike that, he didn't tell you it was okay to remove the battery or disable the exterior security camera, did he?
No, he did not.
You then you entered into the house, didn't you?
Yes,
Now, there is this camera that's in the kitchen, am I correct?
yes,
Now, there are counters there's a counter and then there's a middle island in the kitchen, isn't there?
Yes,
And when you entered into the kitchen, tell me if I'm wrong, what you attempted to do is you actually got down relatively low, right? Between the counter and the island.
no,
And there's a dog that's in the house, right?
yes,
Where was the dog when you entered into the kitchen?
he was in the kitchen.
He was in the kitchen?
Yes, he was. in
That's
the
not
kitchen.
true, is it?
I believe he was in the kitchen. He's locked in the kitchen.
What did you do with the dog when you came into the kitchen?
Well, he has a dresser that blocks the kitchen to the back room. And when I moved the dresser, the dog came from the kitchen and ran through the house.
What did you do? Well, let me ask the question differently. Isn't it true that you beckoned the dog over to you?
No,
Isn't it true that you told that you beckoned the dog over to you so that he wouldn't wake up, Mr. Scatarassi?
no.
Didn't you tell the police that?
I left the dog in the front room so that he
Just
wouldn't
answer my
wake up.
question. Didn't you tell the police that?
I told the police that I left the dog in the front room so that he wouldn't wake up, Andy.
Okay. Isn't it true that you beckoned the dog over?
I didn't beckon him over. He came through himself.
Came through. And when you're in the kitchen, what you did is you actually reached up and you disabled that security camera in the kitchen as well, didn't you?
Yes, it kept going off.
It kept going off, so you disabled it.
Yes,
So now, at that point, I want to be real clear. Mr. Scatarassi was sleeping.
yes,
And what you did at that point was, Mr. Scatarassi, you took his phone, right?
at that point, I tried to get in his laptop.
You tried to get in his laptop. This is his laptop.
Yes,
And you took you took the laptop and you were in the kitchen at that point?
it was sitting on the table already.
So you're in the kitchen at that point.
Yes,
You open it up, correct?
yes,
And then you attempted to type in an access code, didn't you?
yes,
And again, he never gave you permission that night to enter into his laptop, correct?
that night, no.
Right. And you didn't ask him for permission that night to enter into his laptop, particularly in this manner, did you?
No,
And when you tried to type in a code to get access to his laptop,
yes,
did you guess at the code?
it was changed.
It was changed.
Yes,
And we're gonna come back to that in a second. When you couldn't gain access, how many times did you try to access his laptop?
I would say 1 or 2 times.
One or
but
two times.
I'm not sure.
Then, when you weren't able to do that, you then took his phone.
Yes,
And where was Mr. Scatarassi's phone when you took it?
sitting next to him on the couch.
So you snuck over to where he was on the couch,
Yes,
just quiet as possible, yes?
yes,
In an effort not to wake him.
yes,
You then took his phone, like off the counter with your hand, yes?
off the couch. Yes,
Off the couch, yes?
yes,
And then you didn't just attempt to open it up in the house, did you?
no,
You actually walked out of the house, right?
yes,
You then got into your car, correct?
yes,
And then you drove your car to the end of the block, yes?
to Kroger. Yes,
To Kroger. And then you sat there for how long trying to gain access to his phone?
about 10 minutes because it took me about 15 minutes to get home.
How many times did you type in how many codes did you try to enter?
I tried to get the code sent to his phone, so to see if it would pop up on the screen. I would say I tried the code a few times.
You tried to get the code sent to his phone. Tell us what you mean.
He put spyware on my laptop. I had been asking him to give me the code to take it off, and so he wouldn't.
I mean, there are companies that you can hire, like Micro Center and others, to look at computers, right?
Yeah.
Did you hire one of those?
No,
Okay. So you attempted to get a code sent to his phone. From what?
from my computer,
Okay.
the spyware on my computer.
Okay. So
It
you
needed an
tried to get.
access code.
I'm interested specifically in your admitted attempt to access his phone without his permission. I'm asking you about that, okay?
Mhm.
You tried, that's a yes? You tried
Yes.
that 5 times or so in a 10-minute period of time.
I wouldn't say 5. I would have gotten locked out.
Was his,
Objection, mischaracterization. I mean, she said a few times.
I asked and answered as well.
Okay,
It's just,
Rephrase.
sure.
Move on.
I think I've gotten the answer, Judge. Wasn't the phone actually locked out after you returned it to Mr. Scottarossi?
I can't remember.
Okay, so you might have tried enough times to have locked it out.
It is
Okay.
possible.
Yes, ma'am.
I don't think so, but it's possible.
Now, you then brought the phone back to the house, correct?
Yes,
And then this incident, according to, there's this incident that you've described that you say takes place in the house, correct?
yes,
Then after that, we know that you went down to the police department, correct? And that's when you made this statement to the police department.
yes.
All right. Now, when you spoke with the police, you never told the police that you, originally, when you talked to the two police officers, I think it's officers Lieb and Officer Roberts, but Officer Lieb certainly, let me make sure I have the names correct, Your Honor. Officer Lieb, when you first sat down, or you first talked to Officer Lieb, you went through what you say took place. You didn't tell him that you disabled the exterior camera, did you?
Yes, I did. In
You
the
swear-
camera
you-
footage?
I
I
Let me
swear.
answer. Let me just follow up with that. When you first walked into the police department and you went through your rendition of what you say took place, you swear on your oath
On
as
my
a
oath?
witness that you
And let
told
me finish the
Officer,
question.
that you told Officer Lieb at that moment that you disabled the exterior camera.
I don't remember the exact moment that I told them,
So-
but I did tell them in the police station that I disabled the
Right.
cameras.
I'm
I
talking
swear.
about, ma'am, you have to listen to my question. I understand that this is a difficult experience testifying. But my questions are very focused on specific moments. So let me ask it again. I want to know, are you swearing on your oath as a witness that in your initial rendition of what you say took place to Officer Lee, that you told him that you disabled the exterior camera to the house? Yes or no?
Can you explain what initial?
Originally, when you walked into the police department.
I can't recall the exact moment that I told them in the police station, but I
Right.
did in the police
A
station.
few
tell them
moments
that.
ago, I asked you if you told them when you first walked in, and you said you were certain that you said yes. Now you can see that that may not be true. Is that right?
Well, I obviously didn't hear the rest of your sentence. That's why you had to say it again.
Are you, ma'am, I'm just asking you a direct question. If you don't want to answer it, you just say, Mr. Rocket, I don't want to answer it.
It is in the police report, I believe.
Okay. I'm going to ask you again. Have you read the police report?
Not since that night.
What police report did you read?
Well, I reread it after I wrote it.
Right. So I want to be clear. Your testimony is, again, I'm going to be real focused. I asked you a few moments ago whether when you walked into the police department and told officer and spoke with Officer Lee, and I said, are you swearing on your oath that you told Officer Lee at that moment when you first were discussing what you say took place, that you disabled the exterior camera? And your answer was yes. Is that?
Then yes, I do believe when I first went in there, I did say something.
Okay. And then at that same, and you're swearing again on your oath as a witness that you at that same time told the police officer, Officer Lee, that you had disabled the kitchen camera. Is that right?
Can you give me a time frame when you
No,
say that same time?
Ma'am, I'm being as precise as I can be.
Okay, then yes,
And
I
that's-
do swear that when
and
I
you-
was in the police station, I told the story from beginning to end.
Okay. And then you wrote out your written statement. Is that correct?
Correct.
You got a subsequent phone call from the police department, didn't you, after you left?
I did.
And it was the same officers that were speaking with you in the police department, correct?
Correct.
And do you, just to answer this yes or no, do you recall the substance of that conversation?
I believe so.
You do.
Yes.
The substance of the conversation was a question by the officers to you about things that you had not disclosed to them. Isn't that true?
No.
Oh, never mind.
Now, today you testified that you told that Mr. Scottarossi took this, according to this gun, and that he put it up to your chin. That's what yes, that's what you're testifying to.
Then yes.
But you never told, and you took a finger and you held it up to your neck. You didn't tell the police that night, did you?
Yes, I did.
Isn't it true that you told the police that evening that Mr. Scottarossi, according to you, had put this gun, that he'd taken it and put it next to your head? Yes or no?
No.
Isn't that that's not what you said?
I said he put it to my head.
Didn't you show the police where you say he put it?
I did, yes.
And is it your testimony that you actually told the police that he put it to your neck like you just showed us?
Yes.
Isn't it true that that's a lie? That is not what took place.
No.
And that's not what you told the police.
No.
You told the police that he had it beside your head.
This is, in my opinion, beside my head.
Well, ma'am, you're making a
To my
very
neck.
distinct showing of your fingers to your neck with what looks like
In
a
the
gun.
body camera footage of me talking to the police, it says that he put it up to my neck,
All right.
beside my head.
Ma'am, I'm going to ask you these questions. When have you read the police report? Not your written statement. When have you read the police report?
My lawyer did get it, but I haven't read it.
Your
since he's
lawyer
given it
got
to
the
me.
police report
Yes.
because you're referencing a police report. When have you seen the body cam?
I did watch the body camera footage when my lawyer subpoenaed it. I'm not sure when. I think
Your
it was
lawyer in the
last month.
divorce case subpoenaed it.
Yes.
Okay. And your testimony is that, just to be clear, just so we're again, you took two fingers with your thumb, which is supposed to sort of simulate the hammer of the gun, and you put them up to your neck like this. Yes?
When I was explaining it, yes.
And your testimony is that this is what you showed the police when you went to the police department. Yes or no? Yes or no? Ma'am?
I explained to the police exactly.
Ma'am, I'm just asking you
Where
a
he
direct
placed
question.
it on
We're
my
not going
neck.
to play this. I'm asking you a direct
Okay, but in
question.
fairness,
like it's-
hang on. In fairness, she pointed to the left side of it.
Oh, left side. I'm sorry. Left side.
And
Is
you
that-
had yours on the right side.
Yes, sir. If that was the confusion, is that the confusion with my question, that I was using the wrong side?
You're also placing it like this. I explained it like this.
Okay. So for the record, that's the distinction you were drawing?
Yes.
Just fingers and hammer up like this. The weapon, according to you, was holstered, wasn't it?
Yes.
It never left its holster, correct?
No.
The actual, if I understand correctly, the trigger would be blocked by the holster. Am I correct?
No, it was half off.
I'm sorry?
He had his hand on the trigger with it still sitting on the top.
And you told the police that he had his finger on the trigger.
Yes.
So ma'am, I want to show you when the police actually called you back the second time, excuse me, that's a poorly worded question. After you left the police department and the police actually, they called you, we talked about that phone call, right? And the police questioned you about your disabling of the cameras, both in the front of the house and in the kitchen, correct?
Yes, they did.
And they questioned why you hadn't told them about that, correct?
No.
All right, I'm going to approach.
And that's her statement?
Yes, Your Honor.
Okay.
Show her the statement. I'm sorry?
Was that the other one you showed her?
This is the same one. May I approach?
Yes.
May I approach you, ma'am?
Yes.
I want you to take out your written, this is your written statement.
Okay.
May I approach again?
Yes.
Yes.
May I approach you, ma'am?
Yes.
This is a pen. If you would read that to yourself, and would you make a check mark, if you would, next to the spot where you wrote that Mr. Scottarossi, where you wrote that you disabled the exterior camera? Just before
The police asked me specifically
Ma'am?
to put on what happened during the assault and not that. During the body camera footage,
Hang on one sec. Let's
Yes.
slow down.
it's not on.
Wait a minute. I think even if you're not going to move to admit that, we should at least have that
I have no
marked.
problem with that.
So let's have it marked defense 1. Do you want me to have a copy made for you? Is that your
I
only
have a
copy?
But I don't have, you can have this copy.
Okay, so have that marked defense 1.
I'm not moving to the.
I understand. Yes, yes. So why don't you enter my recorder there?
Absolutely. Thank you. So this is defendants 1, and because I'm not moving to admit it as an exhibit, but I think for reference purposes.
I understand.
For the file, it's important. Okay, again, Ms. Scottarossi, let's try this again. I would like you to take that pen, and I would like you to put a check next to the page 1, page 2, whatever line it is, where you wrote that you disabled the front camera. Please put a check there.
It's not here.
Okay, so will you?
I'm sorry, you said it's not in there?
No, it's not on the statement.
Will you please put a check, read that again, please, and please put a check where you wrote that Mr. Scottarossi, or that where you disabled the kitchen camera.
I don't believe it's in here. They
It's
told me
in
not
here.
to put it in here. Yeah.
I'm sorry?
It's in the body camera footage of me talking to the police, but not in my statement. If you would like to admit that.
Ma'am, a few moments ago, I asked you, in response to my questions, I asked whether that was in your written statement, and you testified, yes, it was.
It was in my statement to the police in the lobby, but not in my
Ma'am,
written statement.
listen to my question.
Objection asked and answered. She has answered this
Well,
multiple
I
times.
think that's,
She's clarified what she said in her
Judge,
statement. and what she said.
You asked if I
disagree with-
told
hang
the
on, slow
police.
down.
I'm
It's
sorry.
not your turn to talk.
I'm not big into speaking objections.
No, I'm gonna overrule. You feel free. I understand where you're going with this. Continue.
Thank you. Ma'am, a few moments ago, in response to my question, you said under oath here that in your written statement,
Not in my written statement.
Ma'am,
You
Let
asked
him
if I
finish
told
the
the police.
question, ma'am. Let him finish the question. If the answer is no, that's fine, but let him finish the question.
Okay.
a few moments ago, I asked you a question about whether you had told the police that you had disabled the cameras, the front camera and the kitchen camera. Do you remember that line of questioning?
Yes.
And in response to my questions under oath, you said it was in your written statement. Isn't that what you testified to originally? It's a simple yes or no.
I believe I said it was in my statement to the police. You asked if I told them. I said I told them.
Let's go back again and let's just make sure we're talking about the same thing. I'm going to let you say whatever you want to say whenever you get a chance to say it. I just would like an answer to my specific question, okay?
Okay.
When I asked you a moment ago about whether you told that to the police, in response to that, those questions, you testified under oath that it was in your written statement. Yes or no?
I believe I said it was in my statement.
Okay, so is your answer no? Is your answer
So
you
it's
did not?
unclear.
Ma'am, is your answer no, I didn't testify to that, or is it yes, I did testify to it?
I believe I was trying to say that I told the police this. So I haven't read my statement since the police station that night.
Ma'am,
I just know that I told them
I'm going to ask
everything.
you one more time, and if your answer is, I don't want to answer the question the way you asked Mr. Rockheimer, that'll be the answer. And we'll talk about the weather or the lions or the tigers or something else irrelevant, okay? I'm asking you, I asked you under oath whether your testimony was, it is in my written statement. Yes or no? It's just, there's two answers.
I just understood you differently, so I don't
You understood.
believe so.
Okay.
Yeah.
So in an opportunity with the man approaching it.
Yes.
Sorry. We're in exhibit A, exhibit 1, I'm sorry. The written statement that you testified was accurate and complete. The police gave you all the time that you wanted to write this out, and you signed it. You did not include in this written statement that you had disabled the front camera, correct? Yeah, am I correct?
Correct.
You did not include here that you had actually stood up next to the pilaster or the column, or that you had snuck up to the house in that way, did you?
No.
You did not include that you went into the kitchen and that you actually attempted to disable the kitchen camera, did you?
No.
You didn't include that you actually attempted without authorization to enter into his laptop, did you? You didn't say without his authorization.
No, I didn't say without his authorization.
You didn't say that you took
did say
his
he was
phone
sleeping.
without his authorization and tried to access his phone, did you?
I said he was sleeping.
You didn't, you said he
So
was
no, those
sleeping?
words I didn't use. I believe so. I
Of
haven't
course you
seen it.
didn't. You knew you didn't have authorization to enter into his phone in that way, right?
Objection, badgering the witness. He's.
All right.
Okay. Go through a couple other things here if I could, and then we're going to get back to. That's a pretty harrowing incident, the way you described it, isn't it? Harrowing means, you know what harrowing means?
I know what heroin means.
Okay, yeah, I'm not trying to insult you. I didn't know if you're pausing when I use that word or not. So you described a pretty harrowing, frightening experience. Yeah?
In the moment, yes.
In the moment. And today, you testified that Mr. Scatarassi actually, at one point, according to you, that he looked over at the bedroom windows of your children, his children. Is that right?
Bedroom doors, yes.
Bedroom doors. And you took that to mean that that your children were threatened.
I didn't take that to mean anything. I'm just saying what he said.
You described him looking over. What was the point of you describing him looking over at the two bedroom doors?
To describe the incident.
To describe the incident? You never told the police he looked over at the two bedroom doors, did you?
Yes, I did.
And you never wrote in your written statement you looked over at the two bedroom doors, did you?
I don't believe so.
It's another fact that you omitted, isn't it?
Not in the body cam camera.
All right.
Body cam.
In the body cam footage, I know that sounds like a fallback for you, like a safety valve. You know what that means?
Because it has everything that the police told me I didn't have to right now.
It has everything the police told you. Okay. So when he said everyone and looked at the bedroom doors, I mean, you interpreted that in some way, didn't you?
I did.
You interpreted that to mean that he was a threat to your children.
At the time, yes.
At the time. Okay. This incident occurred on April 10th, right?
Yes.
May 15th, you actually filed for divorce, didn't you?
May what?
May 15th.
I believe it was in the 20s. I can't remember the exact date.
I'm sorry?
I don't remember the exact date. I don't think it was the 15th. I think it was the 20s something.
Your voice is trailing
She's
off.
saying she thinks she filed in the 20-something of May,
Of
not
May,
the
okay.
15th, right?
Well, in a divorce case, you have to verify the complaint when you file for divorce, right?
Yes.
Objection. Again, objection.
Okay, so
Irrelevant.
listen, you gotta.
Irrelevant.
Okay, wait a minute. Let me get you in a good habit right now. When you're objecting, stand up, okay? One, you're standing behind him. Two, I can hardly hear you.
I can move, I'm sorry.
You're
I'm
fine.
saying objection irrelevance. I mean, he's asking about a signed complaint and a divorce complaint.
I disagree.
It's a bit
You're gonna move on
Goes to
how quick,
impeachment.
you're gonna move on how quickly? Ask a couple more questions.
Yes, Your Honor, I'm going through this, and then each thing I go through,
Okay.
will only be
Feel
pretty
free to
relatively
renew
quick.
your objection, Ms. Awad.
Thank you. You had to verify, I just want to, time-wise, I just want to establish that your complaint for divorce, when you filed for divorce against Mr. Scatarassi, you did that after this alleged incident, is that correct?
Yes. But I met my lawyer in March.
And I'm sorry?
I met with my lawyer in March.
In March?
Yes.
Yes. And in your complaint for divorce, you swore, because it's a verified complaint, you swore that you did not know of any issue related to domestic violence or any issue related to neglect or abuse of children that could concern the custody or parenting time of your children. Isn't that true?
I don't remember what's on there, but
May I approach
there
the witness,
wasn't
Your
any
Honor?
charges at the time.
May I approach the witness,
Yes.
Your Honor? My copy of it, it's just a copy of the complaint.
Was that her signing it or her lawyer?
Her lawyer, she had to sign it. So the copy I have one that is unsigned because it was easy to print, but I have one that's actually signed in my computer. It's just, it's like a picture, so it doesn't print easily. But if there's any question about whether she signed it, I'm happy to pull that one up on my screen.
Okay, you can approach the witness.
May I approach you now?
Yes.
I think mark this just for
Defense 2.
defense too. Judge, do you want these? I know they're not admitted, but.
I'm gonna want to keep a copy.
In the file.
Yes.
I can ask a question if you want while we're. marking
Sure,
this.
go ahead.
So I'm going to move to a different subject. After this incident, which you described as harrowing, scary, all that, fair to say that you continued a relationship with Mr. Scatarassi, correct?
A co-parenting relationship.
Only a
Yes.
co-parenting relationship?
Yes.
Didn't you have sex together?
Objection. Your Honor.
Oh, Judge, it's relevant.
Go overruled.
Didn't you have sex together after that?
Is it overruled? There was an intimate moment at my daughter's birthday party. Yes.
I'm sorry?
I didn't hear it either.
Yes, there was an intimate moment at my daughter's birthday party. Well, weekend.
Yeah, you guys went away as a family, right?
It didn't start that way.
You went away May
We
4th.
had her birthday party. Yes.
Ma'am, you went away May 4th, didn't you?
Yes.
You went away for your daughter's birthday.
Yes.
You went to Kalahari, correct?
Yes.
And you and Mr. Scottarossi were intimate, correct?
Yes.
So that's a little bit more than co-parenting when you say at that particular point?
That day, yes, I would say.
Okay, so your testimony that your
Someone-
relationship was limited to quote unquote co-parenting, that's not accurate or true.
One day out of a year, I guess.
Fine,
Yes.
whatever it is, but that testimony was not true.
We went back to co-parenting afterwards.
Okay, I know you want to qualify that. Can I take that as a yes, that it wasn't, that one line wasn't true?
No,
No, I can't.
we still co-parented together
Okay.
and that was it.
May I approach again?
Yes.
May I approach again? This is a copy of your defendant's exhibit number 2. This is the complaint to the date May 15th.
Yes.
And your lawyer, Robert Dubin.
Yes.
And then there's a line for you to sign. I declare the above statements are true to the best of my knowledge, information, and belief.
Yes.
And that you had to verify that before it was submitted as a complaint in the case, correct?
Yes.
And you did that, right?
Verified that I had to sign it?
No, verified. In other words, you had to sign your name saying that this was verified, that the facts in here were true.
Yes.
In page 3, under paragraph 14, C, plaintiff does not know of and has not participated as a party, witness, or in any other capacity, in any other court decision, order, or proceeding, including divorce, separation, neglect, abuse, dependency, guardianship, paternity, termination of parental rights, and protection from domestic violence concerning the custody or parenting time of the children in this state or any other state.
Objection, Your Honor. This paragraph in this exhibit is not relevant.
I
It has
disagree.
nothing to
Let me
do-
see, let me read that. You were reading it kind of fast
Oh,
here.
I'm sorry.
May we approach, Your Honor?
Paragraph C and D are relevant.
Do you want to approach?
Yes.
What, with Mr. Rockhind? You want to approach where?
You, just go ahead and read it first.
Questioning on paragraph C and D, Your Honor. I'll make my offer of proof 2 when the court's ready.
It's not relevant to the case that we have.
Wait a minute, what page are you on this? Were you
Page
showing her?
3.
Judge, it's page 3,
Okay,
and it's paragraph 14,
okay.
then I believe it's paragraphs C and D.
I mean, I'm not sure where you're going with this either. What do you?
Sure, I'll make my offer of proof if the
Go
court
ahead.
wants. My offer of proof is that this complaint for divorce that was filed, which was verified, that the complainant did not in paragraphs, in anywhere in the complaint or in paragraph C or D, indicate that there was an allegation of domestic violence or an allegation of Mr. Scottarossi in any way intimating that he was a threat of harm to their children, which is what she testified to here.
Your Honor, if I may respond. This paragraph specifically is regarding any court decision, order, or proceeding as a party, witness, or in any other capacity. At the time this case had not been initiated, her being a witness in some type of incident report with the police. it
I
does
agree
not
with her,
qualify.
Mr. Rockheim. This complaint was not initiated, although it was authorized back in July of 24. It wasn't authorized by the date of the filing of the complaint, and there was no arraignment on this charge until January 29 of 25. So I'm going to ask you to move on.
Yes, Your Honor. I have one more question if I could about.
Go ahead.
But I won't, but we'll again, I'll leave this here for record purposes. Ms. Scottarossi, would you agree with me that in your divorce complaint, forget about those particular paragraphs, you made no mention, there was no mention or reference to this incident?
Correct.
All right. Ms. Scottarossi, let me ask you, let me move on to a different subject matter. We know that you met with the police and you've written out a written statement and you have spoken with the prosecutor, correct?
Correct.
And during your conversation with me a few moments ago, you talked about things that you used the phrase, well, what was legal and not legal. You remember that? Remember at some point you volunteering an answer saying, well, that's illegal, or that would be
Breaking someone's property.
breaking someone's property.
Yes.
Okay. So I'm going to ask you some questions along those lines. And first I want to just going to ask, was the prosecutor or the detective, not asking about your lawyer, that's different. You don't ever have to answer anything about what your lawyer told you. Understand that? Your
Yes.
divorce lawyer, that's private. Okay.
Yes.
The prosecutor or the detective, did they ever tell you, did they ever give you, discuss with you any crimes that you committed or may have committed or could be accused of having committed on April 10th?
No.
All right, let's go through those and we'll talk about what's illegal and not legal. So we know that you entered into a home at which you were not living at that night on April 10th. You testified to that, right?
Wasn't staying, yes.
Wasn't staying, wasn't living. You told the police you weren't living there, right?
I said I had been gone for a week, yes.
Right. And you entered into that house when somebody was there, which was Mr. Scottarossi. Yes?
My husband, yes.
Ma'am, you entered into the house when a person was there, correct?
Correct.
And you entered into the house with the intent to do something, correct?
Correct.
And the intent was to access his computer, right?
Wait a second. I think I need to get her a lawyer.
You might.
I think I'm going to. Ma'am. Here's what I'm going to do. I'm going to appoint you a lawyer to just talk to you about this, okay? We're not going to rush this. We're going to continue this. I want to give you an opportunity. If anything, I've let it go too long, and that was my mistake. Are you guys good in 2 weeks?
Can I check my calendar?
Please. There's nothing to be afraid about. I'm going to get you a lawyer. I want you to fill out, well, I'm just going to appoint you a good lawyer from MIDC, okay? And at least you can confer with him or her about this before you come back, all right? There's no reason to be upset right now. How about, is everybody good on the 25th, Lisa? Is that in the afternoon?
The afternoon on the 25th is fine. I have a sentencing set for that morning that I know will be involved, but the afternoon I'm fine.
You good on the afternoon, Ms.
I'm checking.
Okay.
That works, Your Honor.
We're going to adjourn this to March the, what did I say? The
25th, Your Honor.
I meant the 18th. I don't know why I said the 25th. Can we do this the 18th? 2 weeks from today.
Yes, Your Honor, that works.
Can we do it at 1 o'clock?
I can do the 18th in the afternoon, Your Honor. Yes,
18th
sir.
at 1 o'clock. Lisa, I want you to.
I have a Zoom hearing, but I have a Zoom PCC, but I think I should be fine, Your Honor.
What?
You have a trial at 1 o'clock and quite a few exams in the morning.
Well, then what kind of trial is that?
It's with Mr. Lechner, David Yak.
That's a misdemeanor?
Yes.
Let's make it at 2. We'll make this at 2 PM. And I want you to appoint her a lawyer. I want to give her, let's appoint Mr. Haynes to talk to her, okay? So we're going to give you a lawyer. There's no reason to be upset. Everybody's going to show up here March 18th at 2 o'clock, okay? Anything else?
No, Your Honor. Thank you.
Anything else?
I'm gonna leave these with the
Please,
court.
and if you want us to make copies, we can do that for you.
I'll take copies with the stickers on, so we have those.
That's fine.
Thank you.
Ms. Alawi, anything else?
Nothing further, Your Honor.
Thank you.
Do you want copies of this? They're gonna make them with the stickers on if you want it with the actual exhibit sticker on.
That's fine.
Okay. Thank you, Judge. Good to see you. Sure. Get copies.
I don't. I'm proud of Thank you. I was just asking her at lunchtime.
Judge decided they went on too long, he's gonna get her a lawyer. They started asking her questions about government and disabled and Christian much. Nothing happened.
They dismissed her and everybody disappeared.
No. Did you say perjury for 5 minutes?
No.
Who are you?
PCC and Shoemaker.
Oh, is he here?
Yes.
You never checked in with me. Is that Shoemaker?
Yeah.
You gotta check in, man. Are you Mr. Barker?
Yes.
Yeah, nobody ever checked in with me.
No.
Didn't know anybody was here.
So fast, I didn't know. I was fairly impressed with what was in it.
What's that? That's, yes. That's it. She's not in here. I don't know where she went. Okay, I'll go track her down. You want me to send her down to the window? Okay. All right, we'll do that. Okay.
Can you give these to him? I don't know. Who-
Does this go to Skirt Azzy's attorney?
Yes, please, thank you.
Yeah.
Okay. No. Yes, please. Thank you. Bye.
Send her down to Lisa. Lisa, she's on her way. Oh, she probably left her thing.
Thank you.
You're welcome. Please down. Yeah, just remember coming up.
Yeah.
You can come up here. You just have to seat till he calls you. Court is back in session.
Okay. All right, Randy Lee Shoemaker, 24B724247.
Good afternoon, the record Stephen Barker, P36030, on behalf of Mr. Shoemaker, who stands to my right.
Sir, your name?
Randy Shoemaker.
All right, so we're going to adjourn this a week.
Yes, Your Honor, we were here last week. Maria, who was prosecuting at that point, and I had discussed their resolution. She felt more comfortable having Mohammed handle that today since he's the regular prosecutor. We talked with Mohammed about the same resolution today. It seemed good, but he wants to get some feedback from his supervisor. So Mr. Mohammed is requesting the extra week, and we have no problem with that.
All right, we'll make it. You know, I'm not going to be here next week, so I think I should handle this. We're going to make it 2 weeks, March the 18th. And, I mean, I have my colleague's going to fill in and do some things, but not so much pre-trials. So what do you have on the 18th for me, Lisa?
9:30.
Is that a good time for you, counsel?
Actually, I have a circuit court matter at 8:30.
Where at? Wayne?
In Oakland County, but it is Zoom. But perhaps if we could do it maybe closer to 11.
As long as I have you here by 11.
Yeah, no, that would be fine.
Okay, but I got to have you here by 11 though, okay?
Well, why don't we say 10:30 then?
All right, 10:30. March 18th at 10:30.
Okay. Your Honor, if I could, my client drives for work. They occasionally send him across the border to Ohio for some of his employment. We'd ask that his bond condition allow him to leave the state for purpose of employment.
Okay. I'm going to continue the $7,500 bond, can leave state for employment without consent, okay?
Very good, Your Honor. Thank you.
Thank you, Your Honor.
Excuse me. Jeez, thank you.
And off the record, I concur with further counsel, Leo trial, you haven't aged at all.
Oh, jeez.
All times I've been.
That's not true. You guys flatter me. I'm getting old.
I don't see you very often, but you always look the same.
Take care. Thanks. Good to have you. Luna? Jacqueline Lee Luna? 24B716755.
Good afternoon, Your Honor. Mohammed on behalf of the people.
And good afternoon, Your Honor. Michael A. Carmen, P73824 on behalf of the defendant.
All right, today's the date scheduled for a bench trial. You ready to proceed, gentlemen?
Judge, the victim in this case failed to appear despite the subpoena being issued. My understanding, based off of my discussion with the officer in charge, is he arrived to the victim's home and he provided the defendant with the victim's subpoena. And I don't know whether or not the defendant provided it to the victim or not, but because it is mother and daughter, I don't know if there's a no contact order in place, but that's
No assaultive behavior toward Luna Dela. Now, this has been going on for a while, hasn't it? All right, so
as of today, all based off of the information that I have, we're unable to move forward because there's no complaining witness present.
Your Honor, based on those facts, the defense would move to dismiss the case, please.
Case dismissed without prejudice. To cancel the bond conditions, Lisa, please. But they can reinitiate the case. I want to be clear about that. Do you understand that, ma'am? Your name?
Jacqueline Luna.
Do you understand that?
Yeah,
Case is being dismissed without prejudice.
okay,
So they could bring it again tomorrow if they wanted. I'm just forewarning.
okay.
Bond conditions will be canceled. Case is dismissed. Good luck to you. They don't usually do that, so I wouldn't lose sleep. Good luck.
Okay. Thank you,
Angela
Your Honor.
Marie Rellinger, 24T725-324.
Good afternoon, Your Honor. Mohammed on behalf of the people.
Good afternoon, Your Honor. Michael A. Carmen, P73824 on behalf of the defendant.
Your name, ma'am?
Angela Marie Rollinger.
All right, so what are we doing here, gentlemen?
Judge, I had an opportunity to speak with the complaining witness in this case, the defendant's mother. And she indicated to me that the heart of what she wants to accomplish here is to ensure that, you know, the defendant's in the drug program and we make sure that she's on a probation. And so I
Drug program.
A drug program. So this stemmed out of a domestic, the victim's position is that this stemmed out of the drug use associated with the defendant, and that's what the drugs, it basically had her behavior act this way in this manner. So we want to treat the root of the issue, which I think is drugs.
Well, Your Honor, you know, we have agreed to a plea where Ms. Rellinger is going to plead guilty to a disorderly conduct under 771. As far as the, you know, there's no sentencing agreement, of course, these are recommendations. So I would leave any of that up to probation. Do not believe, and this happened in November of 2023, Your Honor. So I think that should be determined when she goes for her screening in front of probation, like it is with any other defendant.
And Judge, just to make sure it's clear for the record, the plea that was extended in this case was based off of an agreement with, I understand the court doesn't take sentence agreements, but I would, in this special situation, strongly request that the court adopt the sentence agreement. And that is based on my discussion with the victim. Had I not had my discussion with the victim and she told me those terms, I would have never done this plea. But she's getting a very, very good plea, which is it's under 771, so the case gets dismissed. We just want to treat the heart of the issue, which we think is drugs. At least I believe that based off of what the mother's representing to me.
And Your Honor, I just made a point of clarification about that with my client. She's fine with that. She'll take a drug test today.
Pardon?
She'll take a drug test today.
I don't know what you guys mean. Are you saying that this is a sentence agreement or just a recommendation?
I believe it's a sentence agreement. That's my position on it.
Yeah, and Your Honor, I know the court doesn't take sentencing agreements.
Well,
so.
it's just that I discourage him because I don't know anything about this young lady. I don't know.
But Your Honor, if it's a recommendation, the defense does not oppose it.
All right, look, I'll take the plea. I'll order a screening and assessment. If it shows me there's a drug issue, I'm going to go ahead and order treatment. That's probably what I'm likely to do. If you plead guilty here, ma'am, the possible penalties are up to $500 in fines, 90 days jail, costs or all of those. I'll take this under section 771.1. If you're compliant at the end of a specified term, the case will be dismissed on motion of the prosecutor. That's after I set my conditions. Do you understand that?
Yes.
And the advice of rights.
Yes.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes.
All right, to the charge of disorderly person. How do you plead?
Guilty.
You understand all your rights, correct?
Yes.
All right, give me 1 second here. Were you in the city of Trenton, County of Wayne on at 3350 Edison in Trenton, November 12 of 23?
Yes.
And who was Angela Contrastato?
My mother.
Okay, what happened?
There was a family dispute manner that was loud enough for the neighbors to hear. And
Did you strike her?
in self-defense, Your Honor.
Did you push her?
Yes.
Where is she? What do you mean self-defense? Did she struck you?
Yes,
So this is just a plea straight up to disorderly. I mean, this is the thing when they come in here with a factual basis that's purely on the disorderly, not on the assault and battery. It's kind of hard for me to order anger management programs, right?
I understand, Judge. Maybe we should just do the trial then. I
just,
have 3 eyewitnesses.
I'm just telling you, whatever you guys want to do is up to you. I mean, what's that?
We're okay with the sentencing agreement if the court is. My client's fine with that. We went over that. Anger management, no problem.
And we can stick to the IR as a factual basis.
She just got done telling me that she was loud, that she was acting in self-defense. I don't have a problem, but let's not, you guys want to torture these and go to disorderlies, and that's your business. I try to not get involved in that, but then I got people denying anything happened, and except we got loud. It's like on the larceny cases, the retail fraud, and all of a sudden this new thing is disorderly person. Everybody's disorderly. Well, I either got to take a plea based on a factual basis based on the original charge or on the added count. And she's just denied any kind of an assault. So I'm just telling you.
Judge, it might just be best that we just.
I mean, I got loud. We were loud enough where the neighbors could hear it. That's just such nonsensical gibberish.
Well, what is it, Your Honor? Do you need a plea on disorderly or on domestic violence?
I know, but hang on a second. I'm just telling you, you send me this anger management.
I think this is just a family dispute that got a little
Listen,
out of hand.
that might be. Everything's disorderly. That's all I'm saying. Everything's disorderly. I beat up my wife, it's disorderly. I hit the guy in the head with something, it's disorderly. I steal something, it's disorderly. I mean, when I hear only that people got loud, I'm not going to do much. People have arguments all the time. All the time. I don't know any spouses that I know of that I've ever been friends with that didn't argue with their spouse at some time or another. I mean, that's just the way it is. So you guys, I'll talk to you guys in chambers on this, okay? Let's do that. And give me the other one. We're going to talk about the other one too. Everybody stay seated. Rellinger. Angela Marie Rellinger, 24T725324. Okay, everybody's name again.
Good afternoon, Your Honor. Mohammed on behalf of the people.
Ma'am, your name again.
Angela Marie Rollinger.
Michael A. Carmen, P73824, on behalf of the defendant, Your Honor.
Ma'am, if you plead to disorderly, I'm going to start over. Okay?
Okay.
I just want you to tell me the truth. I don't want you to lie to me, and I don't want to just hear I got a little loud.
Okay.
You're charged with an assault charge, domestic violence. Your lawyer has worked this out where it's going to say that you're going to plead to disorderly. It's going to be under section 771.1 with a recommended terms, and I've explained to them and they understand. I don't have to go along with these. These are not a sentence agreement. It's just anger management, drug program, 12 months probation, additional terms. I'll decide what you're going to do, not the prosecutor. Do you understand that?
Yes.
That's if I take your plea. Do you understand that?
Yes.
You understand the possible penalties are up to 500 in fines, 90 days jail, costs are all of those?
Yes.
And if you plead guilty, I'll set terms and conditions, and if you're compliant at the end of that specified period, the case will be dismissed on motion of the prosecutor. Do you understand that?
Yes, Your Honor.
And did you sign, read, and understand the advice of rights?
Yes, Your Honor.
You plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes.
Okay, you fully understand everything.
Fully understand.
To the charged disorderly person, how do you plead?
Guilty.
Were you in the city of Trenton, county of Wayne on November 12 of 23?
Yes.
And where were you?
My mother's house.
And that was at 3350 Edison?
Yes.
What happened?
There was a disagreement, an argument that became physical. I came in contact with my mother
What do you mean by that?
physically during an argument.
Did you strike her?
Yes.
How?
That's
Push,
it.
punch, slap?
Push and slap.
Were you acting in defense of yourself at the time you did that?
No, Your Honor.
Are you sure?
Yes.
You're not telling me something you think I want to hear, I hope, because all I want to hear is the truth.
No, it's the truth.
So you were the aggressor.
Yes.
She had not struck you or threatened you prior to that. Is that true or false?
True.
Are you on probation?
No.
Parole?
No.
Anybody forced you to plead guilty?
No.
Come on up here, Ms. Constrato. It is accepted. I'll take it under 771.1. How much alcohol did you have that day or drugs, ma'am?
None.
Okay. What is your name?
Angie Marie Varnana.
Come on back up here, Ms. Rellinger.
What was that?
Wait a minute. Just stay right there,
Oh.
both of you. Why are you guys suggesting a drug program? Mr. Muhammad, your name?
Mohammed. Judge, I had an opportunity to speak with the victim, and she believes that the source of the reason that the defendant acted this way in this incident was because she was on drugs. And I think drugs may be a issue for the defendant.
What kind of drugs?
I don't know. I was just told drugs.
What kind of drugs?
I'm assuming pills of some sort. I believe I would have never got struck by my daughter if she was sober or she could have been coming off where she needed them. She's never hit me before.
Well,
Until
that's
now.
there's no reason or justification for that. You don't hit your mother.
Child.
I'm sorry?
I'm sorry.
I didn't hear you.
I just said a mother shouldn't hit their child or start arguments with their child.
Okay. Do I have the police report? Somebody have the police report? Excuse me.
I have Your Honor.
I do as well.
All right. I was just had a note passed to me. You're a little hard of hearing?
Yes, I'm hearing impaired.
Okay, fine. I'm going to keep my voice up. If you can't hear me at any point, just tell me, okay?
Okay.
Who's Masuch? Is he here?
No.
He didn't help the situation, huh? You still going out with him?
Yes.
He's a wise guy too, huh?
No.
I can't imagine saying to anybody, I'll let the dog out of the crate as much as I want, really? Does he own the place? Does he own the dog? Does he own the crate? I'm just telling you, listen to me. Graduate? Your client graduate?
Yes.
I'll take a plea. I'll take the plea. You're not on probation or parole.
No.
I'm prepared to sentence now, but I'm not going to sentence unless, if you guys think there was drugs, I'm not going to go for this speculation that she was under the influence of drugs here. There's no indication in the police report. She's denied it, right? Or were you under the influence of something?
No.
She has told me that steadfast, time and again.
Why are we, this is what I'm talking about. Why are you interjecting things, Mr. Muhammad? You got to have more proof than this.
Well, Judge,
Listen, you got to have more proof than this. You can't just say the mother thinks that. Now, listen, I'm going to sentence her, and I'm going to do what I'm going to do here. And I'm gonna listen to what everybody has to say, and we're gonna go from there. And you, young lady, need to be more respectful.
Yes, sir, I'm sorry.
I'm sorry, I'm not talking about to me. I don't know if it's about you, but I only have one mother. You hit your own mother, there's something sad about that. Listen, don't look at your lawyer. What do you want to say?
Your Honor, this is my client's only run in the criminal justice system at all.
Give me
She's
a
been arrested
probationary.
before. Denies using any substance that day. She's been steadfast in her denial of that to me since, we met. I think this is our fourth time now. Gave me just her version of the events that were typed out in detail to that day. None of them include any type of substance abuse. Would ask that the court order anger management and some community service and find some cause.
Where do you work at?
I was working at a dialysis center in Southgate.
What do you mean were?
I lost it.
When?
When they found out about this event.
When did they find out about this?
December of 2024.
So just a month and a half ago?
Yeah.
2 months ago?
They did a background check and found it.
How long did you work there?
8 months.
Where did you work before that?
I waitress
Where?
at 6 Star, Leo's, Coney Island in Taylor, and then also Mally's in Southgate. And now I also waitress at Big Boys in Wyandotte, Michigan.
What else?
Thought from the defense, Your Honor.
What else?
What else? Sorry?
I'm sorry?
And I'm sorry, she has 3 children. That's also
You have 3 children?
very noteworthy. Sorry.
I can't tell the date of birth. Are you 23 or 4?
24.
It's a lot of kids. And who's the father? Is it the same father?
Yes.
Is it this gentleman?
Yes.
You two want to have contact with one another.
Yes.
Do you want to have contact with your mother?
No.
That's sad.
If you knew the history, Your Honor, it's a bad history.
I can't even tell you how sad I think that is.
Judge, is there some kind of counseling we can do or something? Because I agree, it's extremely sad. I think in the best interest of justice, we should try and address that as well.
I got it. Well, you want to say anything?
No, Your Honor.
Are you still married, ma'am? Yeah, I know. I can understand. That would break your heart as a parent to have your daughter or son say that when they're standing 2 feet from you. It would break your heart, huh? I hope you understand what you're doing. Maybe she hasn't always been the best mother. Maybe we haven't always been the best fathers or mothers in our own right, but you're only going to have one of them. And nobody's going to stand by you more than your parents. Nobody. Nobody. Did you ever tell this guy or you don't want to get married? Yeah, you can talk. You can talk. Did you ever talk to him about marrying you or not? Or you don't want to get married?
I haven't. I'm not sure.
Well, you got 3 kids with him.
Yes.
You must like him.
We've been together 8 years.
8 years. How old's he?
25.
You guys been together since you were
16.
and he was 17.
Yes.
I can't solve all these problems. I really can't. I wish I could. Because I just think it's sad. I really do. I think it's horrible. I mean, this report certainly doesn't indicate your mother was hitting you that day. Doesn't say that. The fact that you think you can hit your mom, I don't care. That's just plain out. Yep, tell her not to say nothing. I would too. That's just plain out, flat out wrong. The fact that you think you can hit your mom.
And Judge, just for the record, like her mother came to me and asked me to make sure nothing happens to her in this case.
Yeah, I know.
It's really heartbreaking.
Well, that is, I don't even know how to word it as a judge. I know what I would say if I wasn't in a courtroom. Someday you're not going to have your mom. And your father of your children there, he's no all-star hero either. He starts lipping off to your mom. See, it just goes down. I know I'm old-fashioned, but it just comes down to some respect here. That's all it comes down to. Maybe they didn't do a very good job of teaching you respect. I don't know if they did or didn't. But clearly you don't have any. My dad upset me multiple times in my life. I'd have jumped off the Empire State Building before I'd have thought about punching him. Or slapping him. Or pushing him. Or frankly, but he was a Marine Corps major, even thinking about talking back to him. You ought not be so quick to point fingers at everybody else. There's still this little hierarchy, right? Parents, we need to show our parents respect. She changed your diaper. They fed you. They cleaned you. They clothed you. They put a roof over your head. Don't forget all that. I'm not going to order this drug. There's no evidence.
Thank you.
Do you have anything else that you want to say, young lady?
Oh.
I know you're going to walk out of here and think that the judge doesn't know what he's talking about. You won't be the first leaving this room to say that. Trust me, I know a lot more than you think. 10 months probation, I'll take it under section 771.1. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. You're not to possess firearms. You're not to possess dangerous weapons. You're not to have any assaultive, abusive, or intimidating behavior toward your mother, which I shouldn't even have to say that. That's just like, you shouldn't have to say that. You attend the domestic violence program, listen, with 8-week follow-up. Attend that. I want you to serve 2 days on the court work program and 1 day of community service, and there's a $35 a day charge for that on the court work for $70. 1 day community service, I want you to complete your community service 8 hours by April the 10th. I'm not going to do a lot more than that. I'm going to give you a review hearing date. I'm telling you, you just seem a little, and I could be wrong. I'm just telling you how I feel. I've been doing this for a few weeks, and I'm telling you, you seem angry, and I'm going to encourage you to let that go. And I would encourage you to never talk to your mother like that again. And then you don't have much respect for the system when you come in here and tell me that you didn't hit her except in self-defense. If that report is anything truthful. So just one observation. Maybe you can find 80,000, maybe all these people in here think you're right. Go talk to them and they can all go out and say the judge is full of himself, doesn't know what he's doing. Should have become a salt fryer at McDonald's and you're the right one. And I don't know, that's what happens. We get around people, right? And everybody wants to tell us what we want to hear. Give me a review hearing date, Lisa. Fines 100, costs 100, 75 victims' rights, $50 justice assessment, 200 in probation fees. So your total's 5.25 plus the court work program fees of 70 for 595. And I'm also going to order attorney fees in the amount of 660. Your total 655. You pay that, you stay out of trouble. I'll give you a review hearing date. And that will be on
December 23rd at 9 o'clock.
December the 23rd. I really hope you two can work this out. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. Do you understand that, ma'am?
Yes.
Your Honor, she will go to probation.
She have money to pay? She has this $500 cash bond. Who's Byron Wolf?
My grandfather, or
She gonna let you apply the bond? You gonna let her apply the bond? Are you going to let her apply the bond? What do you say?
yes,
Okay, so you got $500 to apply. Is that her father?
yes.
Are you still talking to him?
I take care of him, Your Honor. I'm his caretaker in my home.
$500 now, and I'm gonna let you pay the rest in this case by, I'll just give you until April the 30th, okay? Can you pay by then? That'll be another 155. So you'll have to go down the hall and tell them you're willing to have her let the bond apply. I wish you well, young lady. Think about what I said, please.
I'm sorry, what date did you say the remaining 155?
April 30. That's about 8 weeks. I can't do much better than that.
Okay, no, that's very fair, Your Honor, thank you.
It's good to think somebody thinks I'm being fair. Good luck. Where is Mr. Stefani? He needs to sign in his advice of rights form. Can you give that to him, John? Did you have a chance to go over that advice of rights with him? You're gonna meet with probation before you leave, young lady. Come on, sir. Anthony Joseph Stefani, 25W701244. Sir, your name?
Anthony Joseph Stefani.
Mr. Carmen?
Michael A. Carmen, 373 perform on behalf of the defendant.
Ms. Alawi?
Nora Alloway on behalf of the people.
I hope I'm doing better on that name.
You are.
Okay. He's going to plead guilty.
Yes, Your Honor.
There are recommended terms, no deferrals, no nothing, just batterers counseling, no contact with Kelly Jarvis, and a year probation is what they're recommending. Do you understand that and agree to this? First of all, do you want to plead guilty to domestic violence?
Yes, sir.
That is
I'm pleading
punishable.
guilty to
That is punishable by up to 500 fines, 93 days jail, costs are all those. And then I'm going to set the terms. Those are just recommended terms and conditions that they're stating. That's not a sentence agreement, correct?
Correct, Your Honor.
Correct?
100% correct.
All right. Do you understand all that, sir?
Yes, sir.
And just keep your voice up for me.
Yes, sir.
Did you sign the advice of rights?
Yes, sir.
Did you read it and understand it?
Yes, sir.
You plead guilty, you'll be giving up all those rights, and there will
Yes,
not
sir.
be a hearing or a trial. Do you understand that?
Yes, sir.
Any questions on your rights?
No, sir.
You understand them all?
Yes, sir.
To the charge domestic violence, how do you wish to plead?
Guilty, Your Honor.
Were you on January 17 of 25 at 26768 Kirkway Circle in Brownstown?
Yes, sir.
And were you dating at the time, or had you previously dated Kelly Jarvis?
Yes, sir.
What happened?
I pushed my way past her, causing her to fall and scrape her elbow, sir.
Okay. I read some motions today that they filed. Did you push her on the bed flat on her back?
Yes.
And are you on probation or parole?
Yes, yes.
With who?
Miss Hessen next door.
Judge Hessen.
Okay.
What is that for?
That was for DUI.
Were you on,
After-
hang on, were you on probation to her, to Judge Hessen on January 17 of 25, at the time of this offense.
Yes, ma'am. All right, yes, sir.
It's the second one that's called me ma'am today. What?
Yes, sir.
Okay. Okay, so. How long have you been on probation of Judge Hessen?
At least a year.
Do you understand if you plead guilty here, you're giving up your right to a trial, and that would be deemed a violation of probation, and your probation on that case could be revoked, and you could be incarcerated on that charge as a result of this plea and conviction.
I've already talked to Ms. Hessen about this. Yes, sir.
It's Judge Hessen.
Yeah,
Okay?
I talked to Your Honor, missed it. I talked to.
Hang on. I just want to make sure you understand that.
Yes, sir.
Your probation could be revoked as a result of this plea and conviction.
Yes, sir.
And you could be incarcerated on that charge as a result of this plea and conviction. Do you understand that?
Yes, sir.
You still wish to plead guilty?
Yes.
Anybody forced you to plead guilty?
No, sir.
All right, I'll accept your plea. I find it to be inaccurate, please. Kelly Jarvis in here?
She is.
Where is she?
I think she's in one of the rooms. You want her here, Judge?
I mean, let me just check this out a second. Let me see his record. You violated a no contact provision. You pled guilty to that. You're not going to listen to me very well, are you? Just going to take mine as a suggestion, what I tell you to do? Why'd you have contact with her before, sir? When I told you not to.
I seen her outside the courtroom and I asked her, was she really going to?
Give Ms. Jarvis.
I said two sentences to her in the other room, right outside the courtroom, and that was it. The only time I talked to her in 1 month.
Do you live on Kirk? Where do you live now? Well, now you're in jail, but
Wayne County Jail.
Where are you going to get when you get out? Where are you going to go?
My sister's home. She's in the courtroom.
Is that your sister there?
Yes, sir.
How old are you?
45.
Do you work?
I have a job lined up for as soon as I come out of jail.
Where does he have that job lined up? Do you know?
Your Honor, I believe it's construction / tree removal at just various locations around the state.
What do you got, a drug problem or an alcohol problem or both?
Alcohol problem.
Were you under the influence at the time of this?
No, sir.
How often you drinking?
I wasn't drinking then, but I used to drink a lot.
Well, how long is I used to? What do you mean by that? 2 years ago, 2 weeks ago, 2 days ago?
A couple months ago.
You just cold turkey stopped 2 months ago?
No.
Well, I don't know what that means then.
I started, how did it work? I'm having trouble remembering right this second. I have a seizure disorder.
Okay.
I started going to drug treatment classes and going to AA classes. When I got the DUI with Miss Hessen.
Judge Hessen.
Judge Hessen. I'm sorry.
Any evidence that there was alcohol use or drug use at the time of this incident? Either one of you, Mr. Carmen?
Not to my knowledge, Your Honor, no.
Ms. Alloway?
Just victim testimony.
She's going to tell us that he was intoxicated?
Well, according to the police report, yes.
Oh, she said. Look, I'm going to order a screening and assessment. You're going to be screened and assessed and sentencing at a later time. Now, where are you going to live? With your sister, I know you said, but where is that?
27326 Oakcrest Drive.
And that's in Brownstown. I see that on here.
That's what I have lined up for right now, sir, until I get my own
Can I see the victim up here, please? What's your name, ma'am?
Kelly Jarvis.
Who's this with you? The victim's advocate, right?
Yes.
What's your name? So I'm prepared to let him out right now. Are you fearful for your life or anything along those lines? I want you to just be honest with me. I don't want to, there's other ways I can cover this. If you're scared, I want you to tell me.
I just wanted to leave me alone.
And you had dated her at the time, is that right, sir?
Yes, sir. We were living together. The home I was living in. It was Friday night. She was coming home from the bar.
All right.
She left work at 3 o'clock and stayed at the bar till 7 o'clock, or for 7 hours till 10 o'clock at night.
All right. Give me a bond sheet, please. John, all this has to go in that Wellinger file.
Judge, just so you know, he served a jail term for Judge Hessen.
He served what?
He's serving a jail term for Judge Hessen.
Oh, he is?
Gave him
When I
40
left out of
days
here-
on February 18th.
40 more days since February 18th is when he was sentenced. So he served what? 10, 14, so he has 26 days left. Is that right? Left less any good time, statutory credit and that type of thing.
May I speak, sir?
Is that, no, I'm asking you, did you hear me, Lisa?
Yes, I believe that's correct.
Well, then there's no reason for me to hurry this. I was going to let you out. Let's just order a screening and assessment. We'll have probation talk to him. You're going to be in custody on Judge Hessen's case anyways. Can you come back for a sentencing on the 18th, ma'am?
I'll have to ask my employer, but
If it worse, you could Zoom. I want you to understand, I want you staying away from her.
I don't go by her or call her, sir.
Don't write her, don't call her, don't phone her, don't text her, don't see her, don't drive by her house, don't have anybody else do any of those things. Give me a date or a time on March the 18th for the sentence, Lisa.
8:30.
Thank you. We'll do that at 8:30. Well, maybe we should do it a little, yeah, okay, we'll make it 8:30. And you're gonna be screened and assessed today, okay? I'll continue the bond, he'll get credit.
And you said how many days remain on that sentence, Judge Hudson?
26, it sounds like.
26?
Sounds like she gave him 40 and he's been in for 14, so.
Put him to March 30th?
I mean, he should get some statutory good time credit. I don't know where he stands with all that. But he's probably gonna be out, he's probably gonna be out around the 18th or 20th, I would guess.
Did you have more time on Judge Hudson's sentence?
Yes.
Okay.
Yeah.
Okay.
Nice.
Okay, I appreciate it. Good luck. Ms. Holloway? Thank you, Mr. Garman. Thanks for coming, Ms. Jarvis and Victims Advocate. Thank you. We'll see you here in a couple of weeks. Thank you. Good luck.
Your Honor, may I say something?
Not now that everybody's left, you can't.
Well, I just want to tell you the reason why I'm doing time for Miss Hudson is that I went over there after I seen you and asked her to put me in jail and help correct my life and get myself squared away.
Okay.
It's not that she put me in jail. She wanted to keep me on probation. I asked her to please help me out and help me get my life in order.
Okay. I wish you well.
I've been on a mission to get myself together.
I wish you well. Good luck. I really do. Thank you.
Thank you, Your Honor.
Thanks.
Have a safe trip.
Thanks a lot. I appreciate it. Good luck there, ma'am.